unfortunately, for someone has to pay this at the end. We observe so a lot of loss of appetite on the contractor side to absorb more and more unpredictable construction risk, and let's say that reflect on the participation of contractors. I mean, first, let's say there were less and less appetite for some projects. Some tender were even without any tender. What also the client did not realize, I think, at some stage, that all tenders are costing a lot of efforts, but a lot of money also to the contractor in the industry. So CICA and together with EIC, the European International Contractor, have initiated, let's say, a dialogue with the International Development Finance Institution to come up with some new approach and, let's say, the aim to try collectively to de-risk the project. So for one example, I mean, the early contractor involvement example, I mean, can provide a development phase for the complex project and establish a common risk mitigation plan that is shared and then priced, let's say, in complete acceptance with the client. So we are very honored, of course, to have this audience today at CICA. Premise. We have with us in the room, let's say, a representative from the Federation of Europe, of course, and we have EIC, we have FIEC, we have also the new president of CICA, who will replace me today. We have as well some important federation with us. I mean, we have the honor to have the chairman of the presentation of the Federation of China here with us. We have also the president of the Federation of the Islamic country and Saudi Arabia. We have also, of course, our friends from Latin America. I mean, FIEC is here. And I think it's one of the first time we have so many representatives from different parts of the world. We have as well the president of IFAPCA, which is the Federation of the Asia Pacific countries. So to deliver this conference, we had, of course, asked the assistance of various institutions. I mean, the first one, and that we are very honored to have him with us today, is the Professor David Mossey from the King's College of London, who will deliver the keynote speech just after the introduction. I mean, David Mossey is working for a very long time on the topic of collaborative approach, and is one of the, I would say, most knowledgeable party in this subject. We have also with us the great pleasure to have with us FIDIC and NEC, I mean, the contract providers, which are, of course, well known to everyone. I mean, they're also working on the collaborative approach model, as well as other topics that they will develop later in the conference. And I mean, is mainly for sustainability clause, for PPP as well, and for some other new, let's say, suite of contract that they will explain to us where they are and what they do. We have also, let's say, a partnership with DRBF. So DRBF is the Dispute Resolution Board Foundation. Again, another topic where contractors are in high demand, let's say, to try to depart from arbitration, which is costly to everyone. Also, let's say, we would like, as contractors, to solve the problem when they arrive and not 2 or 3 years after the event. I mean, we need, of course, cash to progress in the construction project. So that will be, again, another interesting topic for contractors. I will leave the floor now to Benoît Chauvin, who will introduce in more detail the topic of the conference, and then I will be happy to exchange with you later on. Thank you.
Okay, good morning again, ladies and gentlemen. It's a great pleasure for the EIC president to welcome you to this common EIC and CICA conference dedicated to this collaborative approach, you know. Regarding the main focus of our morning discussion, I will say that the key word will be collaboration. During the first panel, we are going to address this collaboration regarding the contract models, you know. It's not a very new approach because we discussed just before with Professor David Mose, but it's a long time that all humans are trying to make collaborative approach in their project. It's not very new, but fortunately or unfortunately, it's difficult to implement. So we know that, and it's why as EIC we dedicate our last event in Copenhagen, and remember that for most of you, to this kind of collaborative contract models. These new models where we think as EIC and CICA that the collaboration between all stakeholders, I will say client, financial bodies, engineering, construction contractors, maintenance operating is the only way working together between all these stakeholders to deliver in an efficient manner the complex project we are facing in construction. So we think that we need this full collaboration between all these stakeholders to de-risk the project upfront in order to deliver this project on time and on budget, which is our key focus as a construction contractors. So it's why we dedicate this first panel to these collaborative contract models. This panel will be moderated by Tim Hillier, and we will have the pleasure to have Gustavo Martinez, our Vice President at EIC, who is working hard on this topic, part of the panel, together with the representative from NEC and FEDIC. Second way of cooperation, of collaboration, is regarding these very key goals that we have all together in construction. It means to deliver sustainable infrastructures. It's really a key issue nowadays in our new world. And again, we think that collaboration is a must. We need to collaborate between citizens, society, citizen, client, contractors, engineering. Again, if we want to reach this goal of low carbon emissions, carbon neutrality, we need again to work together to achieve this goal. Also because this goal is not so well defined, so we need first to define together what is our goal, our target in terms of sustainability. And it's why, again, collaboration is a must. This panel will be moderated by the OECD representative, Juan Garin. And again, we are going to have the pleasure to have FEDIC and NEC part of the panel. Third type of collaboration I would like to speak about is, I will say, in a project, the last chance to collaborate, which is the final part of the project, when we still have dispute. We might dream that thanks to collaborative approach, we will avoid this type of dispute during the course of the project. But if we have, again, I will say it is a last step where we need, again, collaboration between all parties to avoid dispute and to be in a fair position to solve dispute. So it is the topic of our third panel. This one will be moderated by Mrs. Yasemin Setinel. And also we have the pleasure to have Mr. Jeremy Glover as president of DRBF to attend to this panel and to share with us all our views. So this is a very interesting agenda we have this morning altogether. And again, thank you for coming and attending to this event. And I hope and I'm sure that you will enjoy this discussion this morning, and that you will bring to the table your ideas, and you will be in position to raise your questions in order to enrich the discussion. And now I have the pleasure to leave the floor to our academic expert, one of the best experts from King's College, and I will not introduce you more in details, Professor David Mose, but the floor is yours, and you can introduce this event for us. Thank you very much.
Bonjour, mesdames et messieurs. Je suis très heureux de vous rejoindre aujourd'hui à Paris pour partager mes expériences de contrats collaboratifs pendant ces 25 dernières années. Je vais expliquer comment ces contrats peuvent vous aider à éviter les disputes, améliorer les résultats, protéger l'environnement et augmenter les profits. And now I will speak in English A relief to some of you, but to nobody more than me. Okay. What is the role of collaborative contracts? This is what we're going to look at. Do they make a difference? And how do they make a difference? Are they just a vague expression of our hopes, or are they some specific machinery to do different things and expect different results? 25 years I've been saying this sort of thing. 25 years I've been working on case studies, advising on real projects. This is not theoretical. This is proven and practical and a matter of cause and effect. And the work of the construction sector, it needs the support of contracts that help to deliver better value. It sounds obvious, but it isn't always thought of in those terms. The role of contracts can be somewhat disparaged as a thing you put in the drawer until there's a dispute. And if we run our project by some other means, the contract doesn't help. But if the contract doesn't help, it hinders, it gets in the way. So we want a contract that helps to deliver better economic, social, environmental value by getting in the proposals from all members, including contractors and subcontractors, and implementing those proposals, bringing everyone together. We obviously want to reduce the wasteful cost of disputes. That doesn't help anybody, a dispute. Active risk management is required, early reviews, agreed actions. There are many things we can do. We will talk about them today. And there's also a question of learning, improving efficiency, investment, modernization, profitability through long-term commitments, somehow finding a way to learn from one project to another, because otherwise it is a Groundhog Day. We do some great things on a project, back we go to the beginning to learn them all over again with a different team on the next project. That is not efficient working. Other industries laugh at us to think that we reinvent the wheel in that slightly indulgent way. So long-term commitments, if we can achieve them, are important. Collaborative contracts that achieve the first two definitely improve results. Collaborative contracts that achieve all three have been shown to be, and I quote, an engine room for delivering better, safer, faster, and greener projects. An engine room. The contract really can be an engine room. Otherwise, we're in this strange position, the Bermuda Triangle. Collaborative contracts have to have solid foundations. Otherwise, they are vague and somewhat exotic. If we rely completely on slogans like good faith or no blame or win-win, it sounds very nice, but it isn't very clear. And as I say, we have this Bermuda Triangle of idealistic debate. We all want the best, but outside the room is cynical criticism. People working in a high-risk, low-margin, dangerous environment are not easily persuaded by big words and are easily put off if they're talked down to and told what to do in ways that aren't clear. And if you have the idealistic debate and the cynical criticism, you end up with the unrealized good intentions. That is why this debate that is not new has not made the progress that it logically ought to. People revert to a finance director somewhere saying, give me the lowest price, or a design consultant saying, I don't want to see the contractor until they're on site. Very odd observations that people fall back on despite the logic of a different approach. So we need to start ahead of the contract. The strategy, the procurement process needs to ensure that contractors are selected not on lowest price, but on the more difficult matter of assessing qualitative proposals. Proposals for improved quality, efficiency, safety, risk management, social value, and net zero, for example. And it's a lot harder to do that. It is not against the law. You know, the EU procurement regulations expressly permit a proper evaluation, but it is a lot easier to work out which number is lower than another number and to be tempted to think that that is the best deal. So we have to move the procurement world away from that, because then we have proposals on the table that show who is the best contractor and how they can work with the client and the consultants and what they think about the project, the designs, the risks on the site,
contractors have all this experience and they're not necessarily being invited to share it. Yes, of course, it will go into a bid proposal as a statement of experience, but where is the dialogue after selection? Not in the middle of selection when everybody is at risk. Where is the dialogue about the contractor's views, the manufacturer's views, the subcontractor's views after selection and ahead of start on site? And so that balance of evaluation moves into what I call early supply chain involvement, also known, and that's because the UK government uses that term now, also known as early contractor involvement. Much discussed, another slogan if we're not careful, but it has to be a contractual early appointment for a period during which the contractor sits around the table, paid for their efforts like a consultant, and shares their best ideas with, if not a guarantee, then a very strong chance that they will be the party who will build the project. The concept note that you have suggests that the employer, if necessary, can switch to another contractor if the early contractor involvement doesn't work out. With the greatest respect, I'm not sure that's the way forward. If I'm a contractor and the employer might change their mind after I've shared all my best ideas and go with someone cheaper at the end of the day, well, let us discuss that maybe during the day. There are different approaches to collaboration, but we have to think logically if we want people to join and work with a team. And multi-party integrators, I will talk about that. I will talk about a multi-party integrator contract that I wrote that fits with NEC and that fits with FIDIC, and that is promoted by the European Bank for Reconstruction and Development. This idea that we need to build a bridge between the different parties. Project management achieves that, good project management, but a contractual instrument that connects the different parties enables digital information management through the sharing of IP licenses, mutual commitments to all of the interfaces and deadlines, so that we're not managing different parties in isolation, and a system for joint decision-making across the entire team. This, on a complex project, there is not just one NEC contract, not just one FIDIC contract. And as soon as there are multiple contracts, we have to work out how those contracts operate together if we want to bring in the best proposals for improved value and for management of risk. So who's doing it? I've got to go back, sentimental as I am, to the first collaborative contract, which addresses the 2 points I mentioned of early contractor involvement and a multi-party integrator. That was PPC 2000, which appeared 25 years ago. There is an updated version coming out next year. It is not in a position comparable to NEC or FIDIC, so I won't mention it anymore other than in the context of a particular case study. But it described what I have told you about so far today. But to turn to the parties who you're going to hear from later today, NEC have gone to enormous lengths to create the foundations for a collaborative approach through a set of consistent interlocking contracts that govern real-time project management, more recently that have brought in early supply chain involvement through their option X22, and that give us the right basis on which to try to achieve all of the things I've just described. And FIDIC is in the midst of working on another collaborative suite that aspires to do exactly the same. And that's very interesting. I'm not going to rehearse the history of FIDIC or of NEC, but it is significant that both of them are here today, and it is significant that they're both now starting to think in a consistent manner about collaboration, not as an option or a sort of nice to have, but as a real thing, because as our introductory speakers said, the world has changed and different demands are placed upon us. And if we ignore those, the industry is slipping away from its role in society. So I mentioned FAC1. This is like a commercial break. I will wave it about. Who has heard of the FAC1 form of contract? Give me a show of hands. Oh, thank heaven for that. There was an awkward moment when it could be that nobody would put their hands up. It doesn't operate on its own. It is not a fully fledged system. It is an integrator for other contract forms. It delivers a strategic approach to early supply chain involvement, and it brings together the different parts of a complex project. And I'm delighted that two things happened this year that I have to mention, because it's been around since 2016. It was produced as a research project by King's College London after 2 years of consultation in 14 jurisdictions. So it's been around for a while. But this year, the European Bank for Reconstruction and Development published guidance on the use of FAC1 as an integrator. That is on the EBRD website. And it is linked not only to the efficiency of connecting multiple project contracts, it is also linked to their requirements for sustainable procurement. So I was delighted to see that. And I was equally delighted when I was approached by NEC and we put together joint guidance on how NEC and FAC1 are such a good fit and how they complement each other in delivering collaborative results. So those documents were published this year. They're both online. Very briefly, this is what we're talking about: an umbrella or a bridge between multiple project contracts. It may be used for an award procedure if there are project contracts still to be awarded in multiple phases or multiple projects. It certainly is an enabler of digital technology, which I feel has slipped into a parallel universe. I'd never see the IT people, the BIM people at project meetings. They always seem to be somewhere else doing something else, and they speak a different language. This isn't good enough. Digital information management is the key to success in the modern world, and an integrator helps that be brought to life. Joint activities, doing things together that add value rather than just waiting for someone to tell you what to do, is pretty important. And joint risk management, I will give an example of in a moment. This contract talks about measures of success of the parties working together and the actions you take if that success is not achieved, the rewards you get if it does deliver what it's supposed to. It talks about the integration of designs and the delivery of improved value. These systems, of course, can be spoken about only in the individual project contracts, but the danger then is people think someone else has a better deal. They think only of their own problems and aspirations, and they don't have a stable basis for going the extra mile and for trying to bring to life the collaborative systems we're talking about. Risk management. This is the dark side. You sometimes feel that when people talk about collaboration, they're talking about these sunlit uplands of a perfect world, and they're not being realistic, that they're not recognizing that construction is difficult and dangerous and expensive and risky, and that things go wrong. And so people say, oh yes, collaboration, it's all very well, but what happens when something goes wrong? As if a collaborative system is not equipped to deal with problems. But actually, the early supply chain involvement, the early contractor involvement creates a much better starting point for risk management. Because otherwise, the contractor who's bidding for the project has no opportunity to test the risk assumptions of the client and its consultants. It receives a tender document. It is not invited to say, have we got this right? It's invited to bid. And the next thing you know, you're on site with what may be an undercooked risk appraisal, and certainly a lack of consultation on what might be done to reduce risks. And I need only talk about site investigation. A formulaic approach to site investigation is risk allocation, risk dumping, risk transfer. It's not risk management. It's throwing it over the fence. And it may well get thrown back again by very capable contractors and their advisors. So relying on your own bid position is not the beginning of intelligent risk management. if you have time and a commitment to examine risks critically and collectively during a period of time after selection, proper period of time after selection and ahead of start on site, there is more that you can achieve. And if you follow through with early warning systems and joint decision making on site, you can perpetuate that proactive approach. I mention EPC 2000 because I've tracked that very carefully. It's not a big player in the market, but it has been used on a lot of projects. It's been to court twice as a contract in 25 years. That says to me something about commitment to risk management. I will share one case study. I don't want to overstay my time. One case study which involved a bespoke prototype for FAC1, which was used in conjunction with PPC 2000. And I choose this one because it is online and it was audited by the UK government. So we all have good case studies, but to have one that was audited from every angle and is there and has its proven outturns is sometimes a bit of a luxury. This was a £157 million prison project in an impoverished part of North Wales. The Ministry of Justice went into a multi-party contract with Lend-Lease, ACOM, White Young Green, Capita Simmons and Crown House, and delivered some surprising results. I advised on this project, so I lived and breathed it. They had an ESI, early supply chain involvement, early contractor involvement period of 38 weeks. A long time. They prepared well. That didn't mean that their project was 38 weeks later than it would otherwise have been. There was no question of this causing delay. This was getting organized in advance to do specific things during that period that otherwise would have been done by the consultants on their own. So there's no question of a delay. They achieved 26% efficiency savings by the time they started on site. Now, you might say the Ministry of Justice had bad quantity surveyors or bad budgeting processes, and there was a lot of fat in this, but it was actually in a difficult economic time, and it was a matter of testing design assumptions, testing risk assumptions by a client that undertook this all the time. And this was, you judge for yourselves, but it was serious analysis of how money could be saved and how value could be improved. And they improved value through Lend-Lease and its subcontractors such as Crown House, coming up with innovations, nothing incredibly sexy, but value engineered lighting, review of the best building footprint, environmental improvements. But what I would say is even on that big project, what they had learned from other projects with the same client and what they hoped for in getting more business from the same client were motivators to get the best possible ideas. And then we move into the realm of risk. Why should we help each other to manage risk? If it's someone else's problem, shouldn't we just stay away from it and see what happens? So we had a shortage of precast. This is, you'll have guessed almost immediately when you look at that fourth bullet point, that we're pre-Brexit. It's the only time I'm mentioning that word today. Whether we'd be able to achieve the same today, I leave you to work out. But there was a shortage of precast, and it was managed through collaborative dealings with multiple suppliers in multiple European jurisdictions, and it was managed collaboratively. So the contractor notified the problem. The client was driving precast solutions. We weren't saying, is that a nominated subcontractor or a domestic one whose fault it is? We were looking at the shortage. This prison was so big, it was like building a small town. There was a lot of precast required in a short period. And they did it. They managed that risk. They managed community risk because you had to manage the expectation of having an enormous prison on the edge of a small town in North Wales, and employment opportunities helped, but people said, what's the environmental impact? This was an old munitions site full of asbestos. And so they had a local specialist come up with a solution for mitigating asbestos on site. There would not be trucks going past everybody's house. And there was a £4 million saving. There was a general election in the middle of the preparatory phase, and they jointly reprogrammed to avoid delays. And there was significant social value through 77% of local people working on the site, and the creation of a skills academy. All those things were collaborative results. This project was delivered on time to the requisite quality. It is a fully functioning prison, and the cost savings were extraordinary, as well as the intelligent innovations. So I hope that gives you an idea of what collaboration can achieve in real terms, particularly when linked to digital information management. And so I will end with this. What is the future? An event like today, CICA and EIC have put together something remarkable today, and we should try to build on it. They've put out a concept note which is very thought through. They brought together a remarkable collection of people, and I'm very honored to be standing in front of you. We have compelling evidence of collaboration delivering better results across the piece. I don't know how much more evidence we need. We also have compelling evidence of the number and cost of disputes through traditional, as they put it. Traditional is a wonderful word. It suggests heritage. Traditional to me is old school procurement approaches involving lowest price. That's where all the disputes come from. They don't come from outer space. They don't come from bad faith. They come from a dysfunctional approach to putting together the team and running the contracts. We've got tons of evidence of that. So we have the evidence that collaboration works better, and we have a necessity. As your introductory speakers showed, we have a necessity for change that drives clients and the industry to look for safer, greener, more efficient outcomes. We have at a project level collaborative systems proven by the NEC, and that I hope in due course will be proven by FIDIC, that show better results time and again. Sorry to mention FAC once more, but that has been interesting because it has crossed boundaries. It has been used in civil law as well as common law jurisdiction. It's been translated into 6 languages, and it has delivered in Italy, Spain, and Brazil wind farms, solar plants, urban redevelopment, and a metro extension. It's also being adopted by Fusion for Energy in relation to the Aix-en-Provence initiative and other startups. So as an integrator for whatever project contract is chosen, it has a role to play. So thank you so much for listening to me. I hope that we will explore today how collaborative contracts support improved performance, improved results, improved profitability, and an escape from the collaborative Bermuda Triangle. Messieurs et Mesdames, merci beaucoup pour votre attention. Thank you so much.
Many thanks, Professor Mose, for this very inspiring keynote speech with also very practical highlights and considerations for the contractors. Does anybody has maybe an urgent question to Professor Mose before we move to the next speaker? And I think we can keep you on the stage for also the first session on collaborative contracting. Maybe we will. Oh, yes, we have a.
Hello, good morning, everyone. Thank you so much for the fruitful speech that you give us and the valuable information that we have it. And I can see we are from the other world, from the other part of the world, and we have the same problems, which is the lowest prices, which make always the project not in a good condition and the qualified contractor. My question: how we can balance between getting the qualified and good evaluation contractor and good price if we put ourselves in the project owner position? This is first one. The second one, your point about the procurement plan. Is it advised academically? I'm doing the execution actually in the sites, but academically I don't have that information. Is it recommended for a high value project to a higher procurement firm for the contractor, or do it in house in the contracting company? Thank you.
Thank you. Two very good questions. The system of early contractor involvement, I didn't have an opportunity to run through in detail, but the concept note brings out two very important things. One is that if the client declares its budget, then the bidders are able to say how to deliver the best project for that budget. If the client and its advisors say, if we don't tell them the budget, maybe we'll get a fantastic price far lower, and if we tell them the budget, they'll spend the budget. Well, spending only the budget would be a good thing. You often spend more than your budget. So declare the budget to get the qualitative proposals. The contractor needs to declare their profit and overheads. There's no getting away from it. If the contractor hides how they make their money, nobody will trust them, because they'll say, you're always finding another way to make money and you're not telling me what it is. So that openness creates the machinery through which you can then, for example, conduct a little tender process, a tender process for a specialist works package run by the contractor after they're selected, and have another competition. See who's producing the best M&E results, the best cladding, the best whatever. In other words, the competition doesn't go away. You've run a different competition to start with, and you know what you need to know about each other. And then you explore the components of the project and cost in more detail if and when that's necessary. That's a very basic summary. But I think my point is there is proven machinery for doing that. Your second point about in-house or consultancy, I couldn't possibly comment. I think it depends on client expertise. As with lawyers, procurement consultants need to be told what to do and not allowed to run away with the system. I sometimes feel that the big consultancies in the UK, some of whom will be here today, sort of take it away and make it theirs. The client has to drive this process. I think that would be my emphasis. You need a client who is confident as to how they're going to get the results they want. And then, of course, you use the procurement expertise of the firms that you can access, because they have other points of comparison for you, and they'll make it easier for you to run a good procurement system.
Thank you. Maybe due to time constraints, we will not take any questions for now, but you can save your questions to Professor Mose for the first session on collaborative contracting. And I am very pleased to introduce Mr. Vincent Leloup, who is the chairman of the FIDIC Contract Committee. And Vincent will give us an update on the latest forms of contract developed by FIDIC. So thank you, Vincent.
Good morning, ladies and gentlemen. I'm going to take you to a few news and future developments of FIDIC forms of contracts. So after this excellent and very inspiring introduction from David, thank you, David, for all this. Just a key facts regarding FIDIC contract that I guess most of you are aware about. The FIDIC forms of contract have been in use in the construction industry since 1957. Used in more than 70 countries, so far, available in more than 28 languages. You find them used for international project purposes as well as national project purposes. FIDIC forms are being used currently in certain jurisdictions as their model choice of forms of contracts. Used on both public and private finance projects. Reflects international best practices and are so far the choice of forms of contract by development banks across the world, and whether multilateral development banks or also bilateral development banks. So that's just an illustration of the various partnerships we have at FIDIC with various development banks, either multilateral on the left-hand side with the World Bank, the Asian Development Bank, the African Development Bank, and others. Bilateral development banks and agencies as well. JICA from Japan, AFD from France, Millennium Challenge Corporation from the USA for all their finance projects across the world, and the UN systems as well. In terms of recent, sorry, I went a bit too fast. Recent updates and publications from our side. We published in 2017 the update of our flagship contract, the red, yellow, and silver book forms of contracts. In 2022, we published a reprint. This is something we do generally for our major forms. For those of you in the room who have some gray hair or no hair like me, but I'm probably younger than you, you may remember the 1987 Red Book, and we had a reprint in 1992. So these are things we do regularly. We did the same with our 2017 edition, with some figures of use of those three forms of contract over roughly 140 countries to date. And at the same time, in 2022, we published our guide on the use of those forms of contract. Last year, we published an update, a reprint of our Emerald Book, which is a form of contract based on the FIDIC Yellow Book, but special for the underground works, so typically tunnel works, or any type of construction where you've got a majority of underground works to carry out. It's quite a nice and flexible form, despite being within the umbrella of a yellow book with a lump sum approach. You've got all the excavation and lining works, which are treated on a remeasurement basis, and you've got all of the contract machinery in place to automatically adjust time for completion and price without on the basis of the actual ground condition that you encounter, without the need to do any claim. So it's basically a simplified yellow book for the purpose of underground works. And we published the guide at the same time. FIDIC Green Book 2021, I will come back to it in a minute. Very dear to me, as I was the principal drafter for this one. And guidance memorandum also that we published in the midst of COVID times. We published for the attention of the industry this guidance note here on the left in 2020 to assist users of our form to navigate COVID time. And this has proved extremely useful for the industry, in particular to use our change in law provisions, which is a core clause of our forms of contract, and for any international contract, it's a must-have, and proved extremely useful, especially for contractors all across the world, bringing time and cost relief. Whereas in most of your jurisdiction, when you work on national forms of contract, you don't benefit from the same, except if you are in civil law countries like mine here, where you can rely on hardship provisions at law, but that's not a dominant model that you can find in all legal systems across the world. Also, we publish practice notes. So we published last year this first practice note about dispute avoidance, but from the angle of a dispute board. So that was to emphasize and highlight what a dispute board can do in terms of dispute avoidance, or sometimes the title might be a bit misleading. We have users telling us, what about the dispute avoidance role of the engineer or of the two parties together? This dispute avoidance practice note was dedicated to the dispute board, and we will discuss it later on today with my colleague Daduna, who is here in the room, and Daduna is the General Counsel of FIDIC. In terms of what's in the pipeline for 2025, well, we are always a bit cautious, of course, with planning and timing for publication, because as you know, we at FIDIC, most of our work is delivered by volunteers. So we have all our daily occupations in parallel with our workforce FIDIC. So I'm afraid to say that sometimes the control of the program is not as good as one would like to see in practice. So sometimes we have some slippage in the publication programming, but we do our best to have some acceleration measures from time to time. The Bronze Book Test Edition, it's an ODBO form of contract. It was going to be released next year. Why Test Edition? Simply because we have provided there a contract machinery that we want to get market feedback on. There's been an intense amount of discussions as to whether an alternative, collaborative-based actually approach could be developed for a brownfield infrastructure project due to the amount of uncertainties that you have on those projects. And bearing in mind that we are talking here about an ODBO form of contract, so where a contractor will take over an existing facility, operate it, typically a water supply system, for example, propose some upgrades for the whole system, design those, build those, and then we'll operate those for a long period of time while being committed to performance requirements and giving performance guarantees. Accordingly, of course, that requires a strong due diligence done during the first phase of the contract. PPP 2.0 model contract principles. I will come back to this in a minute. That's going to be a proposal for a rethink and a complete new risk allocation paradigm for the next generation of PPP contract that we are working on right now. Carbon management guidance, this is something which is under development and planned to be released by summer 2025. It's going to be a combination of procurement guidance by means of specific procurement forms to assist users and also development banks to capture all carbon management added value that bidders can bring on the table from the stage of bidding, and then to hold that carbon management commitments of the bidder throughout the contract delivery. So additional clauses have been proposed to be used and plugged into our FIDIC forms of contract. Our existing sets of clauses also have been amended in order to accommodate for this carbon management approach on the simple basis of basically treating carbon like money. That's the underlying principle, and defining both carbon management performance requirements with monitored by KPI, and also, if achieved, rewarded through the through specific bonuses, but also damages in case the commitments have not been fulfilled. So we will hear more about that in the next session this morning, in session 2, actually. Collaborative contracting form, that's something that David mentioned. That's going to be mentioned in our next session, so we'll not dwell on that matter too long. We'll have the pleasure to hear from Mike Hunting, who is part of our task group. David also is part of our task group for this contract form, and this is something which is, of course, high on the agenda for publication toward end of next year. Other initiatives, I would go fast on this. PPP 2.0 model contract. So after we define a new new set of principles, and that's planned for next year. Once this is adopted, then we'll get on with the drafting of model contracts, guide to our 2017 suite of agreements, golden principles also for services agreement, the equivalent of the golden principles we published back in 2019 for our works contracts, our set of subcontracts, offshore wind farm contract also. This is an initiative we started at the end of last year, which is well on the way, and we have a planned publication by the end of 2026. It's going to be based on the FIDIC Yellow Book 2017 form of contract, with, of course, all the necessary additional flesh to cater for the specificities of offshore wind farms, with the role of the marine warranty surveyor, for example, matters such as knock-for-knock liability, which is always a high subject of debate compared to the traditional FIDIC risk allocation to allocate the risk to the best party able to handle it. And other forms also awaited with the GV agreement for contractors. We have the pleasure to have Richard in the room, who is part of the task group. The FIDIC update of the procurement guide, and a form of EPCM contract, which is more targeted for end 2026, beginning of 2027. I would just like to bring your attention to the FIDIC Green Book 2021, the second edition, just for you contractors in the room, as it might be a form of contract of interest for your works. The reason for that is that we have somehow taken the Green Book outside its little corner or its little box where it was put by the market back in 99. You may remember that people were saying the 99 Green Book is only for low capital value project, small, short duration of contract. So people were often saying $500,000, $1 million max, 6 months, 12 months max. While it was absolutely not the intended use initially, but that's where the market has put that form. So we have now expanded on the Green Book. There is more flesh, but it remains concise, brief. You have 26 pages, 14 clauses, 10,000 words roughly. So that's 20% of the size of a Red Book and the Yellow Book. More simple for contract administration, shorter, and in brief, that is a mini Red Book that can also be transformed easily into a mini Yellow Book. And you can use it when the perceived level of risk is low in a project, or where party wish to use a form which does not require significant contract administration and management resources. So in the arena of the development banks, and development banks are often defining that threshold, which is arbitrary, but it is used to define what you consider to be a small works versus large works. So less than $10 million small work, and that's a threshold used by the World Bank, for example. So typically in that category, that can be the form of contract of choice to be put in standard bidding documents. But the value can be higher if conditions 1 and 2 are met. You could be in a large-scale contract, but still the parties want to use a simplified contract machinery. And we've got a growing amount of examples coming today of uses on the Green Book on 20, 30, $40 million contract for pipe works, road works, where basically the level of risk that is faced by the project is considered to be manageable within the frame of a Green Book. Some new features with the Green Book is that we have some ease of administration. You have within the conditions of contract a table summarizing all of the employer's risk and putting in front of it all of the contractor's entitlement, with sometimes a relief which can be time only, for example, for exceptionally adverse climatic conditions or for natural exceptional events. And sometimes the relief can be cost plus EOT or cost plus profit and EOT, cost plus profit being given, of course, when this relates to a breach of contract of the employer or to a wrongdoing of someone acting on behalf of the employer, such as the engineer. So this has the purpose of clarity, and with also the introduction of compensable delay as a notion, as opposed to excusable delay, which give you only time but no money. A new feature also that we wanted to develop is basically the mirror of delay damages, a prolongation cost for the benefit of contractors, acting as a liquidated damages provision for simplicity of contract administration. So basically, we took a formula here, which I will not expand on too much, but in simplistic terms, we have considered that the ballpark approach that your overheads are 20% of the contract price. And those overheads multiplied, this 20% multiplied by the contract price divided by time for completion, give you an allocation of the contract price per day to pay for overheads. With an example here given where you have some 5,500 euro per day roughly on of overheads out of a 20 million euro contract. Depending on the time when you have a critical delay occurring, and of course, compensable delay, that means a delay attributable to the employer under the execution of the works, you have 4 typical bands, which are meant to reflect, the well-known gauss-like type of curve that you have on the screen, and where from you have a progressive ramp-up of the mobilization of resources over the life of a contract. When you are at peak production, you will get 125% of W per day of compensable delay. If you are at the right start of the job or toward the end, of course, your extent of mobilization will be lower. So no rocket science, simplistic stuff, meant to provide for a quick resolution of prolongation cost claim. You know how burdensome it can be on jobs when you have to prove your on-site office overheads. You may have invoices and substantiation for all that, but you know how difficult it can be to be successful in the head office overheads claim. So the whole principle of this is to get it out of the way rapidly without the need of any substantiation. That's the key part. And without the need then to rely on expert evidence, either during the contract delivery itself or later on in front of a dispute board. Actually, in the Green Book, you have an adjudicator, so a one-member dispute board in effect. And then you have arbitration. It's an expedited procedure of the ICC that we have provided for. But nevertheless, with those contract terms being, of course, binding, there would be no need to rely on expert evidence for prolongation cost as an item of claim. Tabulated insurance requirements as well. Forms of communication, we have provided 40 forms, but just feedback from the market. Very often people tell us, okay, very nice, taking over certificate, how does it look like? My interim payment certificate, how does it look like, etc., etc. So we decided to provide for guidance. These forms, of course, are not part of the contract per se, but just provided for guidance for the users to assist them in the contract administration. There are also quite a large extent of flowcharts provided to guide people for understanding the contract machinery, in particular this example here, variation, the two ways of variation that we have under our forms. Sometimes people are still a bit reluctant to consider that the fast-track variation procedure, whereby the engineer issues an immediately binding variation instruction, can actually be implemented. So, of course, we've provided some guidance in this respect, plus a good chunk of guidance note at the back of the Green Book. Now, in terms of PPP 2.0 model contract, so we have decided to mobilize a task group last year, and which has produced some recommendation for the FIDIC board. The recommendation from the task group is that FIDIC doing something in this respect would only be interesting and worth if we look at a complete new approach to PPP contracting, which is a feedback we got from a market survey from many angles in the industry. So the task group, I just put the name in there, but we have Mark Mosley, who is very experienced with PPP projects across the world, and other very experienced practitioners who are working on the development of a new PPP model. And we have recently done a survey. You've got the 4 questions that we raised in this survey to the industry. We are currently analyzing the results. The overall objective of this is to address the shortcomings identified by the practitioners in the industry. One of the shortcomings is an imbalanced risk allocation. The feedback we got from practitioners to say that there is an excessive risk burden transferred to the private partners. Also, inflexibility of contract provisions. That was a recurring feedback we got, where the practitioners were saying that the existing forms of contract supported by pools of lenders were very rigid in application and making it difficult to adapt to changed circumstances. Also, the difficulty to capture long-term investment for PPPs, plus governance issues with some identification of weaknesses in terms of the entities, public entities in charge of managing the PPP projects. So we will have next week in the FIDIC International Contract Users Conference in London a specific discussion about this survey, which will pave the way for our task group to produce a new set of principles for PPP project next year. After which, as I said, we will jump into the model contract drafting per se. So finally, I still have a few seconds just to give you some also insight about what else we do. We have our FIDIC Credentialing Limited services company. So this is FIDIC Credentialing is providing certification to the industry, or some of you might be interested in, especially for your in-house contract managers. We have a certification path for those who wish to become certified contract managers. Procurement specialist is also a new certification path in place since September this year. And these are the certificates issued across the world so far, whether for contract managers, trainers, adjudicators, but also certified consulting engineers and consulting professionals. And as you can see, we have quite a wide coverage across the world for this certification. And also our FIDIC Academy, which is providing training for the construction industry on the use of FIDIC forms of contract, but not only, also on the best construction practices. It has been running since 2022, and as you can see, roughly every year now we are training more than 3,500 participants from 110 countries. The training is delivered online, can be also delivered in person within companies or institutions, and in all the UN languages that can be provided during the delivery of the courses. And finally, next week, our International Contract Users Conference, which is our flagship contract users conference across the world in London. For any of you who might be interested, also, I don't know whether there is any seat available, Daduna, maybe it's fully booked already, yes, I guess. Yeah, okay. So remaining small seats on the side then. Okay, all right. And also for those of you who might be interested, we'll have our annual conference, Global Infrastructure Conference in Cape Town next year in September. Thank you for your attention.
Thank you very much, Vincent. Maybe as for David, if anyone has a question. Yes, we have. And please introduce yourself before asking your question. Thank you.
Christophe Bart, World Association of PPP Units. I'm the executive director. I just wanted to strongly encourage also drafting these PPP updated frameworks, because we see that in the industry, there's only around 350 large-scale public-private partnerships around the globe, and that's a drop in the ocean, if I may say. This is why WAP has started at the beginning of 2024 to have a discussion series of how we can come up with small-scale PPPs. What I mean by that are municipal or subnational public-private partnerships, concessions, which are really relevant in the industry. And I'm really hopeful to see that we can continue that collaboration. But I also think that anticipatory techniques, collaboration, like building bridges, like anticipatory mediation, not waiting until we have a full-blown conflict, are extremely important. So I just wanted to hear from Vincent what he's providing in these model provisions in that sense in the new framework. Thank you.
I cannot really answer to you right now because, as I said, it's work in progress. So we are right now defining the new direction for these PPP forms on the basis of the survey that we are currently analyzing. For the time being, the shortcomings we have identified coming back from the market are those I mentioned, and in particular, the imbalanced risk allocation in PPP projects. That's one of the key feedback we get. Governance, as I said, also. Weaknesses in governance of PPP projects, and the inflexibility of contract forms to adapt to change circumstances. So that's our basis right now. Survey results will be discussed next week, and then the next stage will be brainstorming as to which direction we take on the basis of market feedback. So stay tuned, and see you in 6 months with the results. Well, actually, the involvement is quite large. In our groups, we have representatives from various stakes of the industry. We have contractors representative in our task group now. We have also some experienced consultants on the subject matter, plus also representative of more, I would say, the employer side, concession authorities, etc. And the survey is doing widely, like any of our survey. So we and also once we publish some new principles. Before we publish actually those, we have wide market consultation. You know that, for example, for our carbon management guidance or for our collaborative contract form, we are very close to get market consultation on this. So for carbon management guidance, we will have a market consultation, I think, in January starting. And for collaborative contracting, that's going to be soon after. And this is the opportunity for the whole market to give feedback to us while we draft the new forms.
CICA, we are also always very pleased to be friendly reviewers of FIDIC models of contracts. So we are always happy to circulate any draft documents. So we will also have Vincent will be again on the stage for the third session this morning. So you will have other opportunities to ask questions to Vincent. Or maybe one last short one.
Yeah, one question. And I like the slide because we have started lobbying for collaborative delivery models. And one question which comes up very often is competition for it, especially from the multilateral development bank. So we are not only moving away from the lowest price, but we are also advocating a new form of competition. Question to FIDIC, will you explain in your collaborative delivery model contract also something about how the competition for the winning bidder is done? And in the case of NEC, I'm not familiar whether there is some explanation on competition, but what would be your suggestion? There are some ECI models where you run with 3 teams through the process, or would you say, no, this is a waste of time? Really select the team at the very beginning on soft criteria. What is your suggestion?
They're not soft criteria. They're not soft criteria. They are proper criteria designed to get the best appointee. And I think we have to be clear that running with 3 teams is wasteful and expensive, and it's just deferred decision making. So like Vincent, I can't draw conclusions prematurely, but the consultation that was run on the collaborative form looked at a model for ECI that made clear this was an early contractual appointment. That party has been selected on the basis of a range of criteria. We're not running away from cost. If costs can be known, as I said, we want to know profit, we want to know overheads. If there is a commoditized model that can be priced, price it. If there is indicative cost that can be priced, price it. We're not in some sort of article of faith that says you mustn't look at financial matters. But where the contractor and the manufacturers and the subcontractors have a contribution to make to design, to risk analysis, to programming, then it is premature to ask for a price in its entirety at the point of their selection because it's not accurate. So detailed building up of cost planning, analysis of individual works packages, as I said, the running of competitions led by the selected contractor. The process is entirely transparent. The client and the consultants participate in it. This is like if we were doing a takeover, it's like a proper process of due diligence. You know, it is getting under the skin of it. So the answer to your question, yes, NEC are very clear on their cost models and have a range of very interesting cost models and had that baked into their suite. And yes, my understanding is that in addition to the contract form, FIDIC, for the reasons you've said, will provide guidance on how to procure and how to price.
Yeah, and by the way, if I may, one of the reasons I wanted to introduce the Green Book to you is that the Green Book has been used as a drafting basis for the development of our new collaborative form of contract. Mike Hunting will join us on the stage right after. We'll tell you a bit more about what we do in terms of insights with that initiative. Also, an interesting point to mention is that the Asian Development Bank will very soon, in the next coming weeks, release a standard bidding document, which I have drafted for them with a colleague from FIDIC, Stéphane Giraud, which is a collaborative O&M form of contract for the water infrastructure, where the principle is that on the basis of a Green Book, which was a starting point for the drafting, an experienced O&M contractor on water infrastructure will take over, for example, a water supply system for a city, operated from the start. During the first year and a half of operation, that contractor will perform a diagnostic assessment of the infrastructure, strengths and weaknesses, in order to meet some performance requirements defined by the employer. And we'll put together a priority investment plan to be implemented. The employer will disclose upstream in the bidding document the budget they have for the priority investment plan. And during the course of the contract, the two parties will try to agree on that priority investment plan. We'll completely redefine the baseline together in terms of the performance requirements, the performance guarantees, the performance bonuses, the performance damages. And if they reach an agreement, they move into a second phase where the contractor will implement this priority investment plan. And in parallel of all this, throughout the 5 years, which is the intended duration of this contract, there will be opportunities for quick wins. You know that an experienced O&M contractor on water supply infrastructure can rapidly identify some highly leaking pipes, for example, and just proposing to replace 500 meters of existing pipes may allow to reduce the unaccounted for water in the system by a great amount. So there are opportunities for quick wins with rewards also in terms of the benefit brought to the employer. And if down the line in the second phase, the contractor managed to do better than committed, that means not all of the priority investment plan budget is burned, but still the performance requirements have been achieved. The capital expenditure savings will be shared 50-50 between the contractor and the employer. And if the whole capital expenditure plan has been spent, and if the performance targets have been exceeded, there will be performance bonuses. And there will be no third-party neutral imposing anything on the two parties. So it's completely collaborative. It goes actually in line with your concept paper that you have published with CICA and EIC, where you mentioned that in that case, for this delivery model, at the end of the first phase, which is a kind of early contractor involvement, although the contractor is more than a contractor, is also an operator, there is exit provision. If in this one-to-one relation, no agreement can be reached, and the employer can walk away from the negotiation table. But basically everything is designed to incentivize the two parties to reach an agreement. So this standard bidding document of Asian Development Bank is right now, as we speak, being edited. I made the final review yesterday, you know, the legal editing work where you have issues with the format, the commas missing or things like that, all those niceties. But basically, it's planned to be published by the end of the year. I'm not sure whether ADB will put that on their website, but at least it will be available with their procurement department, so-called PPFD.
Thank you, Vincent. Thank you, David. We also have some more questions in the chat for you, but we will take these questions at the end of the first session. So now I am very pleased to welcome on the stage Mr. Tim Illier. So Tim is a partner, head of construction disputes at Trawers and Hamlins in London. And all the speakers of the first session, you are welcome also to join on the stage. Thank you.
Morning, everyone. Forgive me, I will speak in English. So this session is, well, it's about the challenging bit, it's about the difficult bit. We spoke earlier about the delivery, the execution, and David asked, well, how much more evidence do we need to convince the industry to adopt collaborative models? So this session is really about finding out. So I won't take up any more time for the speakers. We will have a short presentation from each of our speakers, and then there will be an interactive discussion at the end. So if you have questions for our speakers, do save them up and bring them to the final part of the session. So without further ado, I'll introduce our first speaker, Gustavo Martinez. Gustavo is the EIC Vice President and also Chair of the Working Group for Delivering Collaborative Models. So Gustavo, the floor is yours.
Well, good morning. Good morning, everyone. It is a pleasure to be with you tonight and today to talk about the work that we have been doing within our working group in the EIC. Work regarding these collaborative delivery models, models that we believe that can promote efficient, innovative, and sustainable solutions for complex projects. We are not talking only about contracts. We are talking about a different approach to complex projects. So it's what I will try to explain in my presentation. But first, I would like to take just 1 minute to explain for those of you that do not know the EIC, what the EIC is. I mean, the EIC, the European International Contractors, is an industry federation that was funded by the European international construction industry to lobby European and international policymakers to promote a level playing field for our member companies and to showcase European construction excellence, innovation, and sustainable solutions. And exactly this is what we have been doing in our group that I will explain to you now. I mean, but we also have other initiatives, the ones that you can see here, like the toolkit on sustainable infrastructure procurement that we developed together with EFCA, and the Global Gateway Business Advisory Group. Well, we represent 14 European National Contractors Association, representing the interests of construction companies from Spain, from where I come from France, from Italy, from Germany, Austria, and many others. And also, we have 17 companies from the construction-related sector as associated members. Our board is led by our president, Benoit Chauvin, that you already met this morning, but we have representation from contractors with international experience from Europe, like Colas, Strabag, Implenia, Gela, or my home company, Ferrovial, in Spain, just to mention a few ones. Well, let's talk now about our working group. We started a year ago to talk about this. It was in November when 10 European international contractors provided very valuable input together with the engineering sector, represented by EFCA, the European Federation of Engineering, also with colleagues of AECOM. When we decided to start working on this, we all agree that we needed to handle complex projects in a different way. At the end, we have a global experience that we try to leverage. And during our work, we have identified best practice worldwide to create an innovative project management approach that emphasizes teamwork and shared responsibilities. We believe that these CDMs could improve, as I said at the beginning, efficiency, reduce risk, foster innovation, promote sustainable outcomes through collaboration. And we hope that we can provide the guidelines that we see from the construction European industry on the paper that we are producing and that we hope to publish very, very shortly. Okay, let's talk about this paper that we are producing. First, we have an introduction to collaborative delivery models, trying to understand what we mean by this as compared to the traditional delivery models. trying to identify what differentiates both approaches. Second, we explain why we believe that this is relevant now, because I mean we know the challenges that we are facing today in the industry. We all know that we are facing an unpredictable environment with increased complexity, high risk, a lack of skilled personnel and resources, with an increasing dispute environment, what at the end produce a lack or reduced competition. We have seen some projects fail, and a lack of interest from us, from the contractors, to one stage, pure lump sum design and build traditional contracts. Also, we try to explain the advantages that we see for our clients, like an improvement in value for money, increase certainty, a better alignment of interest, transparency, innovation, efficiency, and more suitable outcomes, just to mention a few. We also provide a guide that could help to decide when we believe that this is helpful. We came out with a questionnaire based on the Austrian model with 10 specific questions that capture the degree of complexity of the projects. And we finish with the main characteristics that CDMs should include that are related to the golden rules that you can see here, that I will now explain one by one, because at the end is what summarize our work, okay? Well, these 10 golden rules that you can see here are, first, we need to identify the right project. This does not apply for every single project. I mean, this approach makes sense when there is not a well-defined scope, when there are not clear specifications, when there is not a predictable outcome, when the balance risk distribution and allocation is not possible in an early stage. So in those cases is where it makes sense. But when you have what I just said, I mean, a traditional model could perfectly make sense to keep using it, okay? We are not saying that we should change this completely. We are saying that this approach makes sense in very specific projects, so we need to choose the right project. Also taking into account that we need a specific expertise and capabilities within the teams, okay? Second, the second golden rule that we came out is that we need right teams. I mean, teams within the client, the contractors, the designers, within all the relevant parties involved in these processes. We need a sort of sophistication within those teams to work collaboratively. Because at the end, we need to align the project with the client's vision, improving quality, innovation, and sustainability, and managing risk and ensuring a successful project delivery. The third golden rule is that we see essential a two-stage process. And I mean by this that after a quality-based competitive tender scheme that we have already here what this means, a two-stage process it is needed to come out with efficient, innovative, and sustainable outcomes. And let me elaborate a bit more on this. I mean, after a quality-based tender scheme, and once it has been chosen a team, this team, together with the client, exclusively should be working in the first stage, which is the development phase, is what, I mean, we have here also referred in many countries as an early contractor involvement. But in this development phase is the time to align interests, identify those risks, allocate those risks, propose innovative and sustainable solutions, and price those solutions during this development phase. And after this phase, if a solution has been agreed and priced, then to decide to go to the execution phase. The fourth golden rule is that there should be sufficient time for the development phase. This is crucial. I mean, depending on the complexity of the project, could be longer or shorter, but it's crucial to have enough time to do all what I just explained. The fifth rule is that this development phase should be reimbursed. We understand that to promote a collaborative environment where everybody is on board and committed, the team should work in exclusive basis and being paid for it. Rule number 6 is that we should start from a realistic initial estimated budget. I mean, this is very important as well. And we have seen some projects going through many difficulties, but there was not a realistic initial budget, because after the development phase, this initial budget should be aligned with the cost of the project, okay? Rule number 7 is that we need transparency. It was said by Professor Mosi. I mean, we need to open our books. So we understand that if we go through this route, we should work on an open book approach with a clear risk register. Also, rule number 8 is to hear a clear list of tasks and responsibilities and within the team members. And this is important because we need to ensure accountability and efficient coordination among all stakeholders. Rule number 9 is that we should choose the right contract for each phase. For us, contractors with global experience, we have seen the well-known NEC contracts in many geographies. We have seen now FIDIC coming with a collaborative approach. We have seen in North America other contracts, in Australia, alliances contracts. I mean, we have experience with all contracts. I mean, for us, it's not a one single solution for this. But what we make sure is that we need to understand that for each stage of the process, we need a contract. If you ask contractors, we might say that, I mean, we prefer for the development phase a cost reimbursable contract, and in the execution phase, maybe a target cost NEC type of contract approach with a target cost and a pain and gain mechanism. But there is not a fixed solution on this. And during the execution phase, again, I mean, to choose the right contract. And finally, our 10th rule, last but not least, is that we need to make sure that we have an agile on-site dispute resolution. I mean, this will allow the prompt resolution of issues, ensuring they do not escalate or disrupt the project progress. We understand that by addressing conflicts quickly and effectively, the project team can maintain a collaborative environment and keep the project on track. And I think that after, during the Q&A session, we can explain a bit more on those rules. That is what gathers all the ideas that we collect during our working group. Okay, just to finish and to summarize, I mean, the EIC, we have a vision for the future that address the limitations of traditional delivery models. I mean, we have all suffered these limitations. And we would like to drive a positive change with the proposal that we would like to come out with in our paper. That is an alternative approach for complex projects, alternative that will explain in this paper, that will be explained in this paper, that will provide the guidelines, as I said, for implementing successful CDMs, guidelines that gather our international experience, guidelines designed to facilitate an understanding that following this competitive quality-based tender scheme with a two-stage delivery process can create the collaborative environment that we all need to ensure efficient, reduce risk, foster innovation, and promote sustainable outcomes. And this is what I wanted to explain to you today. So happy to answer any questions later in the Q&A session. Thank you.
Thank you, Gustavo. So yeah, very interesting, especially that two-stage process and the on-site dispute resolution. I'll be interested to explore that later. So next up, we have Peter Higgins, the chairman of the NEC Contract Board. And Peter is going to talk to us about the NEC suite of contracts with a focus on early contractor involvement.
Well, good morning. I just want to talk about collaborative delivery contract, how NEC works. To do that will take me around about 3/4 of an hour. I've been allocated 10 minutes. And I'm not going to talk quickly, so I'm going to have to summarize a few things and just do a few points rather than a lot of it. Ask questions later, grab hold of me later, and I'll fill in any more gaps if I can. But very summary, what I'm going to do is firstly just explain a little bit about why NEC is different, what its intention was. I'm then going to talk about how NEC promotes collaboration within the contract and outside the contract within a broader framework. Then I'll just touch on the ECI model, how that works in a little outline. Firstly, what is NEC? We probably know it's a suite of contracts. It covers all requirements for any kind of work anywhere in the world. Brilliant idea. Whether it works is another question, but that was the idea behind it. We actually don't simply provide a contract for governing the rules, i.e. who's at blame when it goes wrong, but it governs how you manage the contract, how you manage the work at the time. So it's written in a way which can be understood. Plain English, using a language that people can understand as long as they can understand English, and with a structure which is fairly straightforward. We don't deal with legal issues. It's a neutral legal jurisdiction. We try to make it so that it can work in different legal jurisdictions. Just a final point, it's obviously developed by the Institution of Civil Engineers. We've updated it periodically. We're on the 2017 edition at the moment. 3 concepts we had, which govern everything we do with the contract. Flexibility. Use the options. You can choose what kind of contract you need. You don't have to choose a contract based on how you want to pay or how you want to do something. It's flexible that way. It should have worldwide use, as I've mentioned. Clarity, simple to understand. Avoid jargon, avoid legal terms. Get rid of these terms that we think we know what they mean, but people might understand it differently than you do. So try to use very simple language everywhere. And again, the fundamental point, stimulus to good management. The whole intention of the contract is to help people to manage the process properly. I think David talked about this daft idea of putting the contract in the drawer and getting on with the work. No, this is an active contract management manual. Okay, a few things about working together. There's a host of different provisions in the contract which help people to collaborate and work together to get the best result. I'm just going to focus on a few of them here. You may have heard clause 10, mutual trust and cooperation. A bit of a novel idea. Question mark, lawyers say, well, actually, it's not enforceable. Well, it actually sets the structure for how you do everything in the future, working together. It's a good structural starting point. Early warning. A novel idea when we first introduced it. The idea that a contractor would give the client warning of something that's about to go wrong rather than wait until after it's gone wrong and make money out of it. The idea that the client won't tell the contractor about something that's a problem in case the contractor tries to make money out of it. So everybody's keeping quiet. The idea of an early warning now is to get rid of that. If there's something's going to happen, you give a notice, early warning notice, you have a meeting, you get together. All those people involved, the project manager, contractor, fetch the client if needs be, fetch the subcontractor or the supplier in. Bring those people together, have a meeting, sort out, this is the problem, what do we do? It's not a matter of working out whose fault it is, it's a matter of working out the solution. Let's fix this issue before it arises. That's the whole point behind the early warning process. Program. We have an acceptor program, which is not a claims tool, it's a project management tool. It's updated routinely. Every time there's a need for a change, it's changed. The program shows what the contractor intends to do the day the program is issued. Nothing else. Shows what's happened in the past, what's left to be done, how it's going to be done. So again, it's a management tool rather than anything else. Compensation. We deal with it slightly different from most other contracts. If there's an event occurs, the contractor is compensated so that it puts the contractor in a position that he would have been with his initial tender. There's no benefit to the contractor. There's no loss to the contractor. He doesn't lose out because he's using the wrong price for it. He's compensated in full. We actually deal with money and time together. That way we put the project manager in charge of deciding whether to spend more money to do it more quickly or to save money by letting it drag out or whatever it is. Discuss it with the contractor, work out the best way of dealing with this event. So again, a collaborative. Target share. What's not to like about a target share contract? Both the client and the contractor sharing one objective, get rid of waste. One of the biggest problems we have in the construction industry is wasting time, wasting money because we do things wrongly. All of a sudden, we change from the model that says the client says, I don't really care what the contractor spends, that's their problem. We now move to a case where the client says, I've got vested interest in the contractor saving money. Because if the contractor saves money, the contractor makes a bigger profit. Okay, I don't mind, but I'm going to save money as well. So we've got a vested interest in it. So target share really aligns people together far more closely than other issues. Multi-party collaboration. I think I'm going to just move on to the next slide because we've got collaboration across contracts. We've got a range of ways of collaborating where you've got different contracting parties involved in a project. We've got in the contract a multi-party collaboration option X22. This says that the contractor A and contractor B actually work together in some way in solving problems on the interface between them. Get rid of this problems over the face there. We've got a framework contract, which is effectively a call-off contract. It's a way of bringing a number of contractors on board and simply giving them a contract for a piece of work as and when it's needed. If you've got a program of work, it's a good model of doing things. We've now done something with David Mosley on Pack 1. Interesting, talking about collaboration, this is quite an unusual thing. NEC looked at what David's been doing with Pack 1 and said, yeah, that's a good idea. Maybe we should do one like that. We said, that's stupid. David's got a perfectly good contract there. Why don't we collaborate with David Mosley in creating something which works together, NEC and Fact 1? Which is what we've done. And Fact 1 actually is, I put it there in the middle between other things, but it's quite wide because it can deal with a whole range of things where you're working together. So it can deal with the basic simplified calling off arrangement, or it can go through to the next one, which is what we call the NEC4 Alliance contract, which is where all the organizations involved, different contractors, consultants, suppliers, subcontractors as required, come together, sign a single contract where they all work together and they all share in the benefits or the losses of achieving success on that particular project. Quite a difficult model to work with. It's quite interesting in terms of governance. Causes a lot of clients a lot of searching to see whether it actually does fit with their internal governance requirement. But the idea is to all work together and all share in what you achieve on the alliance contract. I want to move now to early contractor involvement, early supplier involvement, call it what you will. As we all know, this is where you bring the contractor in to involve in the design and the planning stage. This is where you get the most benefit. Bringing the contractor in at the end after you've done all your design, you've done all your planning, and simply leave the contractor to go and build it is quite crazy, really. All the skills of the contractor should be brought in to help work out what is the best solution to this particular problem. That will reduce your construction risk because you're getting rid of those unnecessary risks early on by designing them out, by working your contract procedures, your processes, your construction sequences in a way which gets rid of the problem. And of course, that means you're more likely to hit your overall targets at the end. So what's needed for an ECI? This is the biggest problem that people have. Biggest obstacle they have is in terms of awarding an ECI contract. But I don't know what it's going to cost me. So how do I know which contractor to give it to? David just talked at length on that one. Thank you very much. It's a big issue, but it's one you have to solve. You need two things, really. You need pricing information. Those things which you can price now, get prices for, get the prices for those up front now. So they're now commitments. This is what my overhead is. This is my profit margin. This is what the cost of this particular activity that I know I've got to do is going to be. So we've got some individual prices, some pricing information there. But what I always say is so much more fundamental, more important still, is how are you going to get to your prices for stage 2? What process are you using? You contractors have all got pretty good estimating systems. Why can't we use that to work out the prices? Well, you probably will do, but why can't your client and your contractor work together, understanding the estimating system, realizing its benefits, realizing its limitations, and agree how the price is built up? So as part of the pricing information at the time of tender, make sure you've got an understanding as to how your process you're going to follow to get through to a price. Scope. Well, the clients will set out the outline of scope, what they want to achieve. But then during that stage 1 process, the contractor will come forward with all sorts of submissions, technical submissions, saying how they're going to actually provide that. And at the end of the day, that contractor scope will form part of the overall scope for the construction phase. So those are quite crucial things to get started. Once you've got those in place, you've got those things identified in your bid documents, then you can identify the preferred contractor and appoint them. Stage 1, is the design and development, construction planning, all the work that goes in before you start doing the physical work and building this particular project. All done under the NEC on a cost reimbursable basis. Contractors paid in full for the cost of doing that work. Oh, clients will worry about that. The contractor's going to spend all my money and I've got no control over it. Well, you have actually, because the contractor will only do what the project manager agrees needs to be done. So the project manager and contractor are working together, work out what needs to be done in phase one. They will go and do it, and the contractor's paid for that. So you move to phase two when that stage has reached a particular position. Contractor proposals are happy. You're happy with what the contractor put forward, what he's going to build, details of it. That's fine. You know your budget, you've got a budget, it's finalized, it's fixed, everybody's happy with it, you go through. Your prices for stage two, activity schedule, whatever you're going to do is fixed for stage two. And the program is agreed, when you're going to start, how long it's going to take, when you're going to do these various things. And finally, client says, yes, everything's now in place, I'm happy to go ahead. So there's always a fail back position. Says client said, well, for some reason, I just can't go forward anymore. Yeah, I know the budget is there. I know what the budget is. I know the prices and everything else, but my governance says that I can't do the job for that price. I've got to scrap it. We've got to go back to square one and think about some other way solution for my problem. So there is a fallback position there. Now, we talked about price for stage two. We only provide in NEC for a target cost or a cost reimbursable stage two. We don't think that the model we've built works if you go to a fixed price for stage two. You can do it, but we do say if you want to do that, you need to look at how you're going to manage stage one, because we haven't got the management process in stage one to control things. Because in stage one, if you're not collaborating in the same way in stage two, then are you collaborating in the right way in stage one? So there's a bit of an issue there that needs to be thought about if you do want to go for an option A type fixed price contract for stage two. We don't provide for it directly. Not moving to stage two, reasons. Well, the client can decide, I just can't go ahead with it. It's not the project I thought I was going to get. It's not going to achieve what I want. Therefore, I'm scrapping the whole thing. We can't agree the program. We can't agree the prices. We're just out of touch with each other. We can't understand it. It's just not right. We haven't got enough budget to do it. So there's a range of reasons why you don't go forward. And we've actually tried to restrict it that you only go forward with a new contractor on limited grounds if you're unable to agree what the prices of the program are. In other words, the contractor believes that the cost is higher than the client thinks it should be. Then in that case, the client can say, well, I'm sorry, I'm going away because I can't agree with those prices. So I'm now going out to some other alternative procurement process. Of course, the pressure's now on because the client wants this project. We're about to start, and you're now going to go spend another 9 months procuring a new contractor. So the pressure is there to try and agree things. So walk away is a difficult position. We have included provision in there for stating failing to achieve stated performance requirements, but these need to be very specific ones if you're going to rely on that. Very key ones, which are crucially important. Okay, the final now, just key success factors. Number one, client capability. The client must have either in-house or bring in the capability to handle an ECI model. It's different way of working from simply awarding a contract and then the contractor go and do it. You're working together. You need the resources, the capability to do that. You need to fix a design strategy. When is the right time to go? We did a lot of work with the client on early contractor involvement, and they developed something which we actually cynically called a late contractor involvement. They were developing the design to far too great a stage, but then they were trying something where they were putting a contractor in place before they'd even got to a stage where they'd developed the scheme enough to fix a budget. So adequate budget. You must have a budget. You must know what your budget is. So that's going to really define. You need to define your requirements to such a stage that you can work out what a realistic budget is for that, which the contractor can sign up to. Then again, go back to this pricing information. How are you going to get to stage two? It's quite important. If you're going to be successful at this, you need to have a good way of getting to stage two prices. If you don't have that, then you're going to be probably a bit of a battle trying to agree prices later on during the stage one process. Okay, so there are key success factors. I'm going to finish with just a couple of things here. It is used internationally, including UK. It's a range of different projects, so nothing much to show there, just to explain that it's not just a purely domestic contract, it's used quite widely throughout the world at the moment. Don't know if you can scan that one, but if you want to know more about NEC, there's a toolkit there available to you. Download that, and it shows you all the information you might want to know about NEC, get closer involvement, closer understanding, all the things that I would have spelt out if I'd had 3/4 of an hour to do it. So thank you very much for your time.
Thank you, Peter. That was packed full for a 10-minute whistle-stop tour. Lots of key themes there on all collaborative models. So early warning systems, and perhaps crucially expertise, having the expertise to actually deliver these types of contracts. Right, we've heard from the NEC, and obviously now another heavyweight contender in the world of collaborative contracts and contract models is FIDIC. So we've got Mike Hunting, who is the complex programs director at Atkins Reales, and is also a member of the FIDIC task group for developing the collaborative contract FIDIC models. So over to you, Mike.
Thank you, Tim. Good morning, everyone. I think my job's been made a bit easier by the preceding presentations. I think the common themes that are coming through, hopefully you'll see through here as well. But what it really highlights to me is the fact that collaboration and collaborative contracts, it's a spectrum. There's no one size fits all. Often people talk about alliances, which, as shown on Peter's slide, that's kind of the big bang solution. It's complex, it's difficult, it's right for certain situations. But Benoit mentioned the history of collaboration and hundreds of thousands of years of people working together. If you think back to the early caveman who was there hunting small game because that's all one person could go after, it was when we were able to communicate and work collaboratively together, people could go and get the woolly mammoths, the saber-toothed tigers, and actually get a better reward. So a more complex project to go and win those. Hopefully you wouldn't die whilst doing it, and hopefully none of the complex projects that need collaboration are going to kill any of the contractors working on those. But I think it's a really good example of the fact that communication is at the core of good collaboration. And that doesn't necessarily mean an alliance. It works all the way through the spectrum to people with good intentions, mutual trust, to go together and try and achieve things. So what am I going to cover? David mentioned at the start that we can't just rely on positive words, win-win, for example. So I'm going to take us through where we've got to with the FIDIC collaborative contract. As we said, it's coming out hopefully at the end of next year. A lot of work, market engagement still going on. We're going to talk about the aims. That's the nice words bit. I'm going to talk about how we've moved that into principles and what that means, and then how that turns into features of the contract. So we've got a route through from saying actually what we want to achieve to how we're going to achieve it. So first of all, our aims. This might be an obvious one, but actually it's really important that any contract is there to support successful delivery of the project objectives. And there's a question earlier about having multiple contractors at the ECI stage. Actually, I think that's not about project objectives. That's about outcomes. That's about things like design competition. So you might want, I want a bridge to be able to get from A to B. You leave it at that. You put it out to a design competition. Fine, have multiple parties come up with solutions. Once you've gone through that phase, you know what your objectives are going to be, and then you can bring a single contractor in, bring your parties together, and define how you're going to address the actual detailed objectives. So it's really important for us that the contract is aligned around defined project objectives. Secondly, and we've talked about this a lot this morning, be applicable across the whole life of projects. This is not a construction contract, it's a whole life cycle contract. Particularly the two-phase approach has been mentioned several times. So the pre-construction, early supply chain or early contractor involvement, going through the construction life, but also where applicable, think about maintenance, think about operation, think about decommissioning. So end of life activities as well. Thirdly, enabling alignment between parties. By definition, that's what you'd hope a collaboration contract would do. But we can't just rely on best efforts and best endeavors. We actually have to have something in the contract that's going to help people to do that. So it's really important for us that the aim was for the contract to make it easier for people to understand what's expected of them and how they're going to implement that. And as a FIDIC contract, it's important that we're aligned with the FIDIC way of doing things. And there's a couple of key bits there. So firstly, the golden principles. So if you think about the golden principles, there's 5 of them. The first one is about ensuring that the duties and the rights, the roles of any party needs to be appropriate. And again, thinking about that, enabling alignment between parties, being really clear what's expected of everyone, how that's going to work, making sure through the golden principles 2 and 3 that particular conditions are appropriate, that risk and reward is right. We want people to succeed, so we want people to be rewarded. We want the projects to succeed, so we want risk to be managed. Fourthly, all time periods must be reasonable. And that's really critical. Often that's looked at from a FIDIC perspective in terms of giving people enough time to respond, so to say an early warning. But actually, it's also about making sure that the time periods are correct for people to provide information to each other and enable that collaborative behaviour. And fifthly, the final golden principle is about maintaining a dispute adjudication board. And that's a really important tenet. Finally, the wider FIDIC suite and standards. FIDIC's particularly known for the role of the engineer. I'll talk about that a bit more a bit later, and that's really key to success. So what are the key principles? Moving on from the aims. So firstly, integrated management. It's really important if you're going to achieve project objectives that everyone is part of delivering those. Everyone feels that they're empowered to make the program or the project successful. That means joint organisation, integrated management, and I'll come on to how we see that being done in a moment. Secondly, being relationship focused. So it's not just enough to say we want to enable good communication, but actually how do we put that in place? How do we see transparency? How do we get the information sharing that's required? Collaborative decision making. It's really important that we bring that to life. Thirdly, being explicit about the objectives. I've spoken about the project objectives, but actually there's also individual objectives. Are there constraints as well that we might need to bring into bear? For example, there might be a multinational project where a national organisation has certain constraints that mean they will behave in a certain way. That doesn't necessarily mean that you can't move forward, but it needs to be identified, managed from the outset. Similarly, if there's a contractor with a particular supply chain that it's contracted or obligated to use, what does that mean for achieving the project outcomes? Fourthly, whole of life participation. Again, we've spoken about this at length, so I won't dwell on that one. And fifthly, collaborative tools and structure. So how are we going to make it possible to collaborate? What are we going to put in place through the contract, through the guidance that goes alongside the contract, to make that available to teams? And actually that links back to the whys and the aims of what we're doing. So why do we want to have the better outcomes? Why do we need tools to support that? Because actually we know that better outcomes, if you define what you want, you're more likely to get it. And I think that's one of the big challenges that we have with a lot of projects, is that clients explain what they want through a loose scope, or through a scope that's only delivered from one particular angle, and they haven't fully considered what true success looks like. And that means success for the supply chain as well. No client should want their supply chain to be in financial difficulty or to be in dispute. That's not beneficial to any organisation, not least the client. Secondly, the tools and structures to make sure that we're whole life. So the better outcomes, what does that mean? It means making sure that we look at reducing risk early on. Again, themes that we've spoken about earlier in the day. Making sure that we get early warnings in, risk management throughout, so the tools and structures to enable that. And thirdly, with the alignment, we know that better communication does work. David's mentioned that right at the beginning in the keynote. We've got evidence that shows that communication is effective. So moving on from the principles, what are the key features of the FIDIC collaborative contract? So these are really about how we avoid the blockers that we see. So engaging with industry, our own experiences tell us that there are a number of things that we fall down on when working collaboratively. So firstly, multiple bilateral contracts. This is looking to keep it as simple as possible to bring people together. I'm sure others have had the experience. If you have a multi-party agreement, you get parties number 1, 2, and 3 to sign it. You start getting it to parties 4, 5, and 6, by which point party 1 decides it wasn't quite what they wanted to sign in the first place. They come back with amendments, and round we go again and again. So instead, a bilateral contracted party approach with a building block methodology. So elements of contracts that are consistent and can be moved across. Defined project objectives we've talked about, the collaborative principles we've talked about, the guidance to assist adoption. Really important actually, and Vincent mentioned it earlier with some of the examples of the guidance for the red and yellow books, for example. Actually, we want to help people deliver contracts and deliver projects successfully. So putting that in place, and what we'll see in the next slide is a key tenet of the contract, which is the collaborative management team, which I'll talk about in a minute, but they're there to ensure collaboration and they need support to make sure that they can do that role. That's a challenging role. And so we want to make sure there's guidance there. Along the bottom, a couple of the approaches that are included in the contract. So how do we show the integrated flow of information? So you can look at BIM, we can look at information management. How does that actually happen? Again, it's not just a nice to have, it's something that we need to articulate so that people know what's expected of them and then they can meet it. The duty to warn and inform, joint actions. It's not about passing risk from one party to another, but it's about addressing that collaboratively. We've spoken about the range of pricing, really good points around actually target cost, bringing people on board, making profit and overhead visible. Actually, those should all be incentives for getting the job done as well as possible. From my own experience, we've had a very large public sector contract or frameworks for the last 10 years in the UK, and we've been consistently over budget, over the client's budget and loss making for us. We moved to a more collaborative target cost model, and since then every project has been within the client's budget and profitable for us. So this is something that, whilst it feels at first, as mentioned earlier, actually from the client's perspective, if you're not succeeding with all the whipping that goes on with fixed price contracts, why would it work in a target cost model? Actually, it does because everyone can benefit. So my final slide, how do we turn those principles and features into roles and responsibilities? And actually there's three key elements. So the first of those is the employer. Every contract has an employer, but it's really important the employer is active. I think we've alluded to this a little bit, but just really highlighting the fact that it's critical for an employer to be an intelligent client, to have the skills and resource available to fully engage in the project, to make decisions, to be part of the collaborative management team, and to get the outcomes and the objectives that they want to. The engineer, key role for FIDIC, and actually here their role is not just the traditional FIDIC role and administering the contract, but it's facilitating the collaborative process. And the collaborative process is something that's defined in the contract, and it does need someone to make sure that it's being adhered to. And thirdly, the collaborative management team. So the collaborative management team, really important way of delivering the collaborative element. Each of the main parties, and that needs to be taken into consideration on a project by project basis, but it could include key subcontractors, key suppliers, as well as contractors, consultants, engineer, the employer, come together to work and deliver the collaborative decision making that's required. That means understanding, communicating risks. It means key decisions that are going to be aligned around the project objectives. So this is where the project objectives really drive the behaviours of everyone, not just the employer. It's a few bullet points here. I won't go through them, and I know we're running a little bit over time. But this is really sort of a key tenet. And if there's any questions around that, we want to talk about it later. We think it's quite an exciting development because it's putting people in a room to collaborate to get jobs done. 99% of the people I know in the industry come to work to get projects built and get the job done. So let's put them together to do that. I think that's it, Tim. So I'll hand back to you.
Thank you, Mike. Yeah, very interesting, the collaborative management team and the role of the engineer. I just sort of draw some parallels there with perhaps the core group from the PPC suite of contracts. And yeah, a tough gig, I would imagine, but perhaps we can speak about that later. Right, next up, we have Christophe Leboeuf from Basics. Christophe is the Business Development Manager, and he is going to present a real-life case study using a collaborative model. So Christophe, over to you.
Thank you. Good morning, everyone. I'm here to present you a case study. So I thought it was good to travel a bit and to bring you to a nice place. So let's go to Brazil. So we are in Porto Nave port, which is in Navegantes area, so Santa Catarina state in Brazil. Client is TIL, Terminal Investment Limited. They are part of MSC Group. And the project is a 900-meter quay wall that needs improvement. I'm not here to bother you with many technical details. I will go straight to the point. So the genesis of the project, the client has launched a typical EPC tender in 2019. So we internally, let's say our management had no real appetite to go to Brazil, difficult country in terms of taxes. We've never been there. It's far away from our head office, let's say like that. So it was very difficult, but we submit a first tender in September and then a second one in November. And in early 2020, client decided to continue the journey with another contractor. So they said that we were not selected. But that was not a good time. COVID time was not helping the client to do progress. They had also enough time to think about their project. And they came back to us in 2021, mid of the year, again to ask us to refresh our price. And that was really not our interest to do so, not to enter again in a competitive EPC tender. And we really wanted to propose and take the opportunity to propose another approach to the client. So ECI came to our mind, and we proposed that to the client. So that was not easy at the beginning because client was not used to it. They were not really open to it, but with a bit of discussion, they accept the approach, and they wanted to have a two-stage ECI, but I will come back to that in a minute. And then it ended up for us mid of 22 to sign an EPC contract, and we are currently doing the project. So just a lot of things have been said about collaborative delivery model and ECI already, but I'm just mentioning again a definition that I like. So an early contractor involvement is used for complex and unusual projects where client and contractors are collaborating. This is very important to develop a solution for the project that reduce risk and improve and secure the overall project cost and schedule. So for us, it was not a competitive ECI. It was really single source, and that's important to mention. And I like the idea mentioned by Peter. It was target shared. So the rules from the beginning were clear, what we want to achieve and where we want to go. And one important thing, and we mentioned that very often this morning already, is the trust between the parties. That's key to success. So you really need to have the trust between the parties, not right from the beginning because you are gaining trust, but it is not something that you have from the day one. But it is very important to build up this relation with your client or as a client with your contractor. And then the second thing, which was also more comfortable for us, is the fact that there is a compensation for this work. So we are paid for that. So we are compensated, which means you can dedicate a team for that. You can have the right people to develop the project. Then what made the difference in our case, because I'm here to give you a practical example, is the problem of the client was a technical problem. We speak about quay wall improvement, which means they have a technical issue. That was not really a budget issue. And that's why we proposed this ECI approach, saying that for us, the problem were linked to the uncertainties of the countries. We never worked before, difficult in terms of taxes, etc. And we were convinced that it was much better for us to enter in this balance approach in terms of risk, because we can put everything on the table. We had the feeling from the beginning also with the discussion that a technical wedding was possible. So they are their consultant, technical consultant. We are our specialist. And on the beginning of the discussion, we had this feeling that it was possible to come to a conclusion together. And then what is very important, and what was very important for us, is that we could put all the risk on the table and really go to a risk-sharing approach with our client. So when you decide to move forward, two big phases for us, very similar to what we discussed already today. We didn't use a typical format, NEC or FIDIC or any kind of approach. It was really something that we defined the rules together. But the first phase was consisting of developing 3 different technical solutions in terms of all aspects. And then we choose together with the client one technical solution that we decide to develop further in terms of planning, constructability, availability of equipment, etc. We go to the open book estimate, and there, this is very important to mention that you will, and we had to disclose our overhead and profit, of course. That's giving also more transparency to the process, and that's avoiding also discussion when you need to sign the contract. The rules are clear. They know what you are going to gain, and they are more comfortable with that. And it's also good to mention that the associated risks were evaluated, and client was taking some risk on board. We were taking some risk on board. And then you move to the second phase, which was supposed to be incorporating clients' feedback, review the specification, and that's very important because typical EPC tender, you have the employer requirement, you put some qualification, and then sometimes they just drop the qualification and you end up with some conflictual situation. For us, we were really insisting on the necessity of reviewing the employer requirement together with the client and adjust the requirement to avoid disputes in the future. And that giving you much more comfort when you execute the project is that you know that what needs to be built, it's according to what you have foreseen in your price, and you don't come on every single differences in the ER and entering in big discussion. So next one, very important, and that's why I mentioned that two important things in ECI, the collaboration. So collaboration means that for me, you need to be fully transparent with your clients, which means that the contractor can really demonstrate that he's capable to do the job and he's the right partner. And the second thing is the client can appreciate and comment the solution with his view as a client. So that was what you can do in the first phase. You can really gain the trust while you are collaborating with them. And in the second phase, I will say that that's one of the most difficult parts for us and for the client as well, I think, is that when you enter in this construction phase, you must entertain this collaborative approach. You need to keep it because you gain the trust, the collaboration is there, the spirit is there, but then you sign an EPC contract and you enter in your typical way of doing the job. But you have to do everything to keep this collaboration in mind while you are executing the project. And I would say that it is maybe more easy to do that when all the risks have been put on the table. You discuss about, you review the ERs, you spend 6 months together discussing about this project. Then I'll say, even if it's an EPC fixed price, you can still do the job with a collaborative mindset. So the takeaways of this exercise, and that is mentioned in the paper that we are going to develop, but I think when you have a project with uncertainty in the scope, when you have high risk profile project, when you have the possibility to innovate, when you really have a lot of risk and you want to mitigate them, then for sure ECI is a good form of contract. And if I come back to our example today, I think it's very important that you define the rules right from the beginning. So there is a clear understanding of the project objectives between the parties. So that's point number one. Point number two, dare to say no to your client as a contractor if you have the feeling that you are leaving the balanced relations. So you have to say no to your client and you have to come back to a normal situation. Collaboration and trust we mentioned already, but what I can add also is that very important point for the client and for the contractor, you need a team, a competent team. So we are speaking about capability of your client. You need competent team on both sides of the table because they will have to take decision. They are not used to that. They are used to take decision when the project is under execution. But when you do an ECI, they are around the table and they have to take decision. And that's a bit of, let's say, education. They need to get used to it. And we are coming from a very conservative world. Step back possibilities, we mentioned that. I wanted to add also, it's also important that you have the possibility on both sides of the table to stop the process if necessary. And to conclude, what I want to say is that the world has changed a lot. We have new challenges, and I'm happy to see that we have also a new approach in our industry. Clients now are keen to develop the project with this kind of approach. So collaborative delivery model are coming more and more in the discussion. We are trying to sell it or to put it on the table with the client, and they are listening. Thank you.
Thank you, Christophe. So I'm conscious we are running quite significantly over time, but are we okay? We're okay for some questions. Okay, so if you have a question, then please do just sort of briefly introduce yourself, and if you're able to, if there's a particular member of the panel that you'd like to ask a question to, then obviously let me know. Otherwise, we'll throw it open to discussion. So questions from the floor.
Good morning. My name is Shada Kavici from Vinci Construction. I had a particular question more directed at Peter, if I may. It's about NEC Alliance. It's still a fairly new type of contract for us as a contractor. And you mentioned governance, which is one of the biggest challenges for us. I was wondering if you had any particular examples of the NEC4 Alliance contract being used, particularly in major infrastructure projects. And if so, what type of stakeholders were involved, and was it considered a success?
Yes, there have been a small number of cases where NEC Alliance has been used. What I have to say is that, turn on, isn't it? Yes. What I have to say is that in each case, the parties have decided to make some subtle adjustments to it, mainly to deal with the governance issues. It's a bit of a problem, you say, for Vinci, but it's also a big problem for many clients, particularly public sector clients who worry about it. So it's been used by the Highways Agency in the UK for their managed motorways project. They've been fairly successful in that. It's been developed in Belgium for the Antwerp Ring Road. It's been used for that project. So there's a few projects around, but in each case, I must be quite clear with you, the parties have felt a need to change it. So whilst we've got a very pure model, the market may not be quite ready for that pure model just yet.
I may, just for you to know, I mean, the country that maybe has developed more alliances contracts in the world, from my point of view, is Australia. They have a very well-defined alliance contract. I mean, we have seen it working in different contracts in Australia, where the governance is very well explained how the approach is. And what I love of that contract is the no blame on any of the parties. There are problems, and everybody should be on board in facing those problems and fixing those problems when they ever come.
Yes, thank you. Good morning. My name is Sergio Liete from the European Commission, Director General for International Partnerships. My question, well, it's to all the panel, but based on the last case study that you have presented, I saw that the decision of the contracting authority or the employer to engage in this collaborative contract with you was after the failure, let's say, of an open competition, and then they started with you. And my general question is how, in your experience, the contracting authorities are justifying, legally justifying the fact that they are engaged in collaborative contracts, and or if they first use kind of call for expressions of interest or tendering process, what would be the process that is mainly used in your experience? Thank you.
I would say that the client was a private client, is a private client, so they have decided to go to this typical EPC tender because they are used to it. But then during this process, they realize, as I was mentioning, that their problem was more a technical problem. And even with discussing with the selected contractor or the parties, they didn't reach an agreement because they were not convinced of this technical approach. We were lucky that they had time. They have enough time with COVID period, and because that was a live port, they were gaining money, so they had the opportunity to delay this process. That was not an emergency case, so they had the possibility to discuss again, and they realized that even if they were losing a bit of time, the fact that they go again to the market and we propose an approach that was not proposed by others, say, let's work together for 6 months. If we agree, we proceed together. I think it would have been better for them to do that from the day one, but again, it's difficult. I know some people don't like that, but conservative world still things are changing, but people are used to other way of contracting.
Okay, do we have any more questions? No. Okay, well, in that case, perhaps you could join me in thanking all of our speakers in the usual way.
Thank you very much, Tim, and all the speakers. So we can have a short coffee break, maybe 15 minutes.
You can try, you can line up a piece, you can great. But they don't really take the time to question it. So as you say, they say, oh, I picked up the big software criteria. With accuracy with the but they use that. Yeah, but they say it's all law firms and so on. Yeah. So you guys take photos with that? I'm not quite sure where's the best place to stand. Usually there. I'll pretend I'm speaking, shall I? And that's probably the best way of doing it. So speaking to a packed audience of hundreds of people. That's it. You've got kids too. We hold them.
One over two in fact.
Okay.
Something that you will only find people on the will jumping selected with this.
our industry, so the sustainable project in the context of the new delivery model. Before entering into the core discussion, into the core topic, let me quite briefly, discuss with you about the sustainability strategy in WeBuild. Just a few words without entering into details, but as WeBuild, we promote a sustainable world. We can proudly say that 93 million people are benefit from our ongoing project in terms of sustainability, sustainable mobility, clean hydro energy, clean water, and green building. I will not enter into the key figure, but just to underline that among our resultant target, the most relevant for today's discussion is in terms of greenhouse gas emission intensity, scope 1 and 2. We set a target for 2025, a reduction of 50%. In 2023, we exceeded our target with minus 67%. Going to the main discussion for today. So the contractor role, contractor perspective of sustainable infrastructure. As a contractor, we are a key player in delivering sustainable infrastructure. Our decision, our method, our practice have a significant impact on the environmental, social, but also economic outcome of the project. We are aware that as the demand for greener construction grows, the demand for sustainable infrastructure grows, we are aware that we must adapt to integrate sustainability into our project. On the other hand, we should be also aware that sustainable infrastructure is not only about meeting the current needs, but also ensuring longevity, resiliency, and minimal environmental footprint for future generations. So we are in between of these two in these two principles. But all these, let's say, quite positive theoretical principle would not be achievable without a strong collaboration among all the parties we have been mentioning for all this conference today. But I want to focus on this principle. And on this regard, collaboration now is more crucial than ever. I would like to mention a very interesting manifesto from ESC, Anchored and FIEC, manifesto on achieving carbon and resource neutrality. For me, it's quite interesting this passage among all the manifesto about collaboration. So if you want to shift from a linear business model to a circular business model, of course, we need to shift from fragmentation to collaboration. So again, collaboration it's central in this new trend. Contractor, as I said, it's playing a fundamental role. We'll have to forge new alliances, as said, with client, with consultant, supplier, but also with the financial institution and regulation. And we are of the opinion that the tool to achieve this strong collaboration will be a new operating model. So the collaborative delivery model we'll be discussing today. So there is a strong connection between collaborative delivery model and sustainable achieving the net zero goals, the green goals in infrastructure. Passing to, let's say, a more technical aspect from a legal contractor perspective, I am of the opinion that the demand for greener project has been having two major shifts for contractor. A procurement shift, let's say, new procurement rules which are reshaping how construction projects are planned, delivered, managed, of course, with the focus on reducing carbon emission and enhancing sustainability. This across the all project phases, starting from the tender phase, so with the new procurement rules. As you know, traditionally, procurement decisions were focused on cost, quality, and delivery timeline. Now, the new positive trend is that environmental performance from bidder, from contractor is a key consideration, with the result that sustainability requirements and criteria are included into procurement process. That's a fact that we need to be aware from contractor perspective. Second major shift is on contract management perspective, with the inclusion of new clauses, specific clauses to ensure that construction project contribute to achieving the net zero carbon goals. We, as we build as contractor, we've been monitoring this trend, but also at European International Contractor Working Group level. We have been monitoring, we've been analyzing this new positive trend. We will hear from NEC, from FIDIC, new mechanism, but there are some share elements among all these new clauses. New or additional contractor responsibility to minimize the carbon footprint of their activities. Of course, there will be a certain extent of flexibility about this additional scope of work, but in general, this could include sourcing low carbon material, using energy efficient construction technique, and reducing waste, etc. Second, additional obligation for contractor is in terms of carbon measurement and reporting. So contractors shall monitor carbon emissions from mechanical construction activities, material transport, but also on the operation of the completed building. Third shared element is the inclusion into these new clauses of penalties and incentive related to sustainability performance. So financial penalties for failing to meet emission reduction target, and or also incentive for exceeding the sustainability goals. Having now described the new environment where contractor shall operate, I consider useful from contractor perspective to focus on challenging solution and benefit of this new positive trend. When we talk about challenges, meaning major obstacle implementation, I have listed some obstacle. Of course, it's open to discussion, to add also additional elements on this. But there could be some cost pressure issues because sustainable material and new technologies can have an higher upfront cost, which sometimes client may resist. There could be a skill gap, lack of technical knowledge or skilled workforce in sustainable practice. There could be a supply chain topic also, difficulties in sourcing sustainable material or dealing with suppliers which could be unfamiliar with sustainable practices. There could be also some issue in regulatory compliance, navigating complex and evolving environmental regulation and certification, but also complex reporting in line with the new obligation for contractor, challenges in accurately measuring and reporting emission. In terms of solution, from a contractor perspective, to summarize this quite standard topic, I try to categorize, to group the set of possible solution. Of course, also here it's an open discussion into three areas, three principles: clearness and transparency, focus on the whole procurement cycle impact, and market analysis. So clearness and transparency, first of all, principle of the mechanism on how the carbon calculation is made during tender and during the execution must be clearly defined. For example, what tool or methodology and documentation has to be used. But also scoring methodology and contract award criteria must be clearly defined in the procurement document to ensure transparency and a common understanding by all bidder. When I talk about clearness and transparency, I'm also thinking about a clear risk allocation among the parties, clear and fair allocation among the parties. So I also included a solution from contractor perspective, the fact that we would avoid the financial incentive or disincentive mechanism, which could result ineffective, and also can increase dispute among the parties. This is strictly related to the mechanism on CO2. We should find an objective mechanism, a transparent mechanism to measure, which is also connected to the performance measure of contractor, and so possible dispute among the parties. As an alternative, if client is willing to include the incentive, the solution is to avoid an unlimited contractor exposure on this incentive and damages, introducing a maximum liability cap. So a maximum liability cap related to the performance, sustainable performance, to the disincentive applied, the liability damages applied. When we talk about focus on the whole procurement cycle impact, The core principle already been anticipated during this conference is that the influence on the total carbon footprint is getting smaller as the project is progressing. So we should identify opportunities for improvement over the entire life of the project rather than merely in the construction phase, with again, a principle already discussed in detail with an early engagement of the relevant party, including contractor, for example, on the base case carbon budget. This will be one of the key for one possible solution. Talking about the third pillar, third principle, market analysis, I am of the opinion that the market analysis from employer before tender phase will be fundamental to identify whether sustainable requirements are feasible for contractor, but also for the whole supply chain. With the result, with the let's say good market analysis, proper market analysis, that there will be a fair distinction between requirement, which shall be realistic and based on previous market analysis, and criteria. Once you pass the requirement, pass or fail, if you pass with criteria, contractor can distinguish themselves the highest strategical investment and commitment in terms of sustainability, the highest score you will get. So it's also an incentive in investing in technologies and in sustainability performance for contractor. Talking about benefit, of course, if contractor will be able to face this positive but challenging trend, there will be some undoubtable benefit for contractor. I'm thinking of 4 benefits in terms of reputation and market leadership. If you will be recognized as a leader in sustainability, this will enhance our competitive advantage by adding value to our bid for future contracts. In terms of operational efficiency, of course, sustainable projects often lead to more efficient construction processes and long-term saving. In terms of risk mitigation, lower risk in terms of environmental penalties or damage claim, and future-proofing business. If we, as contractor, will be able to adapt to global sustainability trend and regulation, this will for sure safeguard our business resilience for the future. My final slide is about the main takeaways from a contractor perspective. So contractor has to be seen as a fundamental change agent. Contractors are central to the successful delivery of sustainable infrastructure in collaboration with their stakeholders. So again, collaboration is the key principle in this new trend. Contractor early engagement to influence the carbon footprint is one of the key factors. Integrated sustainability into infrastructure project benefit not only the environment, but also society and business also for contractor. And last principle is that overcoming the listed challenges require innovation in terms of new technologies, new skill for professional collaboration, as said, but also focus on long-term value. Thank you for your attention.
Thank you very much, Andrea. Thank you for those remarks. And I think you gave us some really good advice on how to embed sustainability in contracts. And now I'm delighted to introduce our next speaker, Jeremy Glover. Jeremy is president of the Dispute Resolution Board Foundation. He is also a member of the FIDIC Net Zero Task Group and a partner at Fenwick Elliott. He's going to speak to us about the FIDIC carbon management guidance.
Brilliant. Thank you. And thank you, Andrea. And it's my pleasure to be presenting details about the FIDIC carbon management guide. As has been said, I am a member of the FIDIC the task group, but the views are mine, not necessarily those of FIDIC. But so I'm a member of the task group. You'll see from that list there that I am the only lawyer who is on the task group. And I'm aware that some of you may think that that's a good thing. And I'm also aware that some of you may think that's one lawyer too many. But the point about it is the rest of the task group is made up of consultants, engineers, and contractors who are already part of the teams in their respective firms who are doing innovative things to help promote sustainable outcomes on their projects. They're the people who have a vested interest in making these things work. And one thing that FIDIC's very keen on, and lawyers should be very keen on as well, is making sure that their contracts are not an obstacle to enabling sustainable development. And that's been the clear focus of this task group. It's something that's very important to FIDIC and those who are involved in it. Now, happily, Vincent's already said that the guide is going out to the market in January of next year. And it's important to think that it's guidance. It's not just a clause, and it deals, as Vincent said, with the whole procurement cycle. And so it offers examples. It gives guidance on all the various terms, and it takes you through the procurement process. And it's also based on a life cycle approach. The guidance focuses on this whole life cycle approach, which you need to do if you're basically considering how to combat carbon emissions, how to deal with carbon change. You've got to think of every aspect of the project: land use, design, construction, operation, and what's often forgotten about, end of life. How are you going to repurpose that building, recycle, reuse, or decommission? So guidance looks through all those stages. Contents, well, nothing perhaps that there's too much of a surprise there. Wanted to highlight defined terms. We're talking about new things. There's a tendency when you're talking about new things for everyone to use different terms. It's important that we're all on the same page, all using the same terminology. That's part of being transparent, and that's part of being open. And I've already talked about the importance of the use of examples. So FIDIC has set out 6 carbon management principles. And I just want to concentrate perhaps on the first one, because that's something that's already been highlighted and discussed on more than one occasion during the discussions today. David talked about the need for balanced evaluation criteria, which is the foundation for collaboration. And one of the other things that FIDIC has been doing in preparing this guidance is collaborating and working with the development banks. And you'll all remember that Enzo De Laurentiis from the World Bank in September of last year introduced rated criteria. And he said that rated criteria help better manage environmental, social, supply chain, cybersecurity risks, and also leveraging new opportunities for green procurement. So it's been very important that FIDIC has involved the development banks with the stages of developing this guidance. You can also see in Carbon Management Principle 1 that the carbon budget is not something that's going to be imposed on contractors. It's something that's going to be proposed by contractors as part of the tender information. FIDIC aren't asking contractors to work to a budget that's been imposed by an outside party. Now, obviously, that imposes obligations on owners and employers when they're putting together the tender information to ensure that that information is adequate for the tenderers to be able to consider the carbon budget. And I think that helps answer some of the, puts FIDIC in line with some of the themes that were discussed by Andrea. Number 3, principle 3, promoting measures that lead to fewer emissions rather than relying on removals or offsets. It's encouraging people to actually do something rather than passing the buck, passing the offsets off to often places further away from the development. If you're acting on a particular development, your obligation should be to reduce the carbon emissions in the environment and the surroundings of where that project is being constructed, not passing the buck somewhere else to another continent. And personally, I think that's quite something that's quite important. And I've touched on the need for the employers to establish a clear, unambiguous carbon emissions calculation methodology. That actually goes to Andrea's point. Well, the employer and the owner must actually be clear that the project is suitable for the adoption of a carbon budget in the first place. And if it's not, they shouldn't be trying to promote it. So going back to procurement, Gustavo also said this, he talked about competitive quality-based tendering. David said there shouldn't be soft criteria. Now, what FIDIC is proposing, that the carbon emissions budget is part of the rated criteria exercise. So contractors are going to be judged not just on price, they're going to be judged on technical issues, which may include sustainability, and also they'll be judged on the carbon emissions budget. It's the whole picture. So competitive, quality-based tendering is all part of the FIDIC approach to the carbon emissions management. And also there's guidance across all the contracts. There's guidance across the services agreements for consultants. You know, some of the key issues here, measurement. Another absolutely fundamental thing that's been touched on many times this morning. How do you do it? Your consultants need to understand how to do it. And so it's and they need to be clear and transparent about how the carbon removal, the carbon elements are actually being measured. And capacity building, super important to FIDIC, super important to the development, super important to everyone in the room. Something that people need to be thinking about, continuous improvement. And there's also guidance for the works contracts, as you would imagine, and they're all going to be slightly different. Every FIDIC contract is slightly different, but so that I think is important. And so, but it's what aiming for in terms of the contract itself. There is an element of greening the FIDIC contracts. There are amendments that are being made to the FIDIC contract. For example, it was said that I'm president of the DRBF. What about dispute boards? Well, dispute boards are being taken out of the carbon budget. And there are two reasons for that. One is that the carbon footprint of a dispute board is tiny in compared to the whole elements of a long 4 or 5 year construction project. It's very small. Now, there is guidance for dispute board members of how they're supposed to operate to reduce their carbon budget. But the other reason it's been taken out of the carbon budget is that FIDIC, golden principle number 5, you have a dispute board. What FIDIC is worried about is a barrier to the implementation of the dispute board. Someone's going to say, oh, well, the dispute board's using lots of carbon, therefore we shouldn't have a dispute board. So that's why the dispute board has been taken out of the carbon budget. And then we called it Clause A at the moment, which is the clause dealing with the carbon budget. And it comes in 6 parts. Definitions I've spoken about. Obligations. Now it's quite a short section on obligations. You need to achieve the carbon budget, but you also need to collaborate to achieve carbon emissions objectives. Now, use of the word collaboration. Members of TG23, including myself, have spoken with members of the on the contracts committee dealing with the collaborative contract to see that the two approaches are aligned so that we're joined up. We're looking to see how parties can actually collaborate. And there was discussion this morning about the importance about setting objectives in contracts when we're talking about collaborative contracting. We're also asking parties to share data. The engineers share data with the contractors, and not just current data, but we're dealing with new technologies. We're dealing with changing technologies. So there should be a proposal to share emerging data. And that's why there is a clause about meetings. FIDIC's already got clauses about meetings. FIDIC understands the importance of communicating when it comes to collaboration, but we want there to be meetings about the carbon emissions process because it's sharing experiences, learning from those experiences. And that's, you've got a reporting clause and you prepare the reports and then you can discuss those in the meetings. Budget changes, well, we're adopting familiar FIDIC approaches. The idea has been to minimize the changes to the existing contracts because quite often some of the things we're talking about, well, we found, oh, the FIDIC contract already deals with that. So we don't want to actually be making those changes, but there are changes. And so there's a process to enable the carbon budget to be changed. And if the reason the carbon budget's gone up, nothing to do with the contractor, well, that's going to be recorded. So that's there. And then the final one, incentives and damages. It's something that Andrea talked about. The idea really is that if the actual costs are less than the agreed
carbon budget. Then there is the payment of carbon emissions incentives. And these will be at a pre-agreed rate based on the carbon cost. Now, if it goes the other way and the contractor goes over the carbon budget, well, yes, then there will be damages. Now, my personal experience is that most contracts you see, the standard bespoke contracts, don't have incentives. They only have the penalty. And that's particularly unfair because it's not balanced, but it's also unfair because FIDIC's quite unusual, I think, actually saying, well, the contractor, you set the budget. And when it comes to the damages, well, they're part of the existing cap. They're going to be included within the cap that's there in clause 1.15, so they're not going to be open-ended. And the way it seems to me, well, it's sort of similar to the approach in a pain gain share. It's the idea, if you have a schedule of performance guarantees, that's actually the same as having a budget. So it's nothing really new, it's nothing really innovative, but collaboration is all about sharing the benefits of success. And if the contractor is able to come in under the actual budget, then I think that's actually particularly important. And the other smaller thing, I probably should have swapped these around, it's not one carbon budget to the end of the project, because different parts of the project have different milestones. So there is a milestone approach. And then it's part of the taking over. You have to have a final report on the budget before you can actually have the taking over certificate. So I'm sorry that's a very quick whistle-top tour, but it's a whistle-top tour of some of the highlights of what FIDIC is looking to introduce. And so obviously we'd welcome any comments from you in January when you get to see the final document. So thank you.
Thank you very much, Jeremy. I was particularly interested in the proposal and having the carbon emission budget as part of the rated criteria. Our next speaker is Peter Higgins. Peter, as you know, is the chair of the NEC4 contract board, and he's going to tell us about the NEC Climate Change Clause X29.
Well, good morning. You got me again. I'm going to throw this open by explaining how the NEC contract clause, which is now drafted and available for use, actually works, what it can do and what it doesn't do. But first of all, just a little bit of a refresh as to how we got into this, because I always like to think about how we got to where we are. Obviously, infrastructure is a big contributor to problems of climate change. And we need to do something about it. We need to really do something more serious about it. So that was pushing us at the NEC to start thinking about how we deal with it. And then we thought, well, it's actually not just a simple matter of do we simplify it in construction, but you've got to look at it all the way. I think you've already mentioned that you need to go right from the very start. So in your planning, in your design, as well as in your construction and in your after life, when you're operating the model, and then you're decommissioning, demolishing, whatever you're doing, you need to think about what that effect has right the way through from the very start. So when you're starting with the early stages of design, you need to think about what the impact of this will be when you come to decommission it or when you come to operate it. That's quite important issues. Now, if we're looking at reducing the impact of climate change, basically that's a scope matter. Scope is a thing which defines in the contract what the contractor has to do and what constraints you've got. So this is a requirement to do certain things and a constraint on how you do it. So it's a scope issue. So getting very simplistic, you could just say, well, it's in the scope. We don't need to do that. Scope's a breach of contract, and if it's a defect, it's got to be corrected. What's the problem? Well, the problem with that, of course, is that relies on the client working out in detail what it is that they're going to put in the scope, how they're going to present it within the scope, and then finding a way of making sure that fits with the contractual processes for when things don't go quite the way that you hoped they were going to go. So that led us to the conclusion we need to drive a clause. So this was aimed at strengthening these contract controls. There are contract controls in the contract already, but you need to find a way of implementing them. This is a way of bringing them forward. It's included in every one of our contracts. All services, supplies, construction, subcontract, every piece of work has got this option equivalent clause in it. What it does, introduce these three things: climate change requirements, climate change plan, and performance table. And I'll go through each of those in a moment. The way that it's done is typical of NEC. It provides complete flexibility on how you're going to use it. And what's quite key point is that this isn't the clause which tells you how to do it. It's a clause that tells you how you can implement it. It's an enabler, how you can make it work. It doesn't give you numbers to put in there, doesn't give you the specifics you need to go in there, but it enables you to put those in and shows you how to work it and what the consequences are that you want to apply from those figures. So first one, climate change requirements. These are the requirements the contractor has to achieve, which can be how you do the work or something that is put in the works. It could be either. You can include all of those things in climate change requirements. They are part of the scope, which of course means that they can be changed during the contract if in fact becomes sensible to do so. Project managers in control of that decision. Now, they must be realistic and they must be achievable. If you put a target in there, a requirement in there, which cannot be met, then that is really quite daft, isn't it? So you need to think about what your requirements are, how you're going to achieve them, are they realistic, are they achievable, and of course, on top of that, how are you going to measure them? How are you going to measure whether you've achieved them? So if you don't achieve a requirement in that will be a breach of contract. That is dealt with within the performance table. So there's a direct link between the performance climate change requirements and the performance table. So if the failure to achieve it is a failure in the performance table, that is a cost that would need to be paid on that. I'll deal in more detail about the performance table in a moment. But of course, coming back, since it's part of the scope, if it's a defect of part of the works has not been built in accordance with those requirements, that's a defect which also has to be corrected. Now, usually climate change requirements will be developed and set by the client, but that's not necessarily the case. They could be proposed by bidders. They could be developed by bidders from outlines. The bidder could be invited to explain what they think the requirement should be based on client proposals. And then that, of course, can be assessed as part of the procurement process. So there's a system there for perhaps bringing the contractor in at an early stage in looking at these requirements and how it can be better. If the contractor does make some proposals in relation to climate change requirements, some proposals on that, they need to be brought back into the contract so they become part of the contractual climate change requirements. We now have a thing called a climate change plan. Typical NEC fashion, this spells out how the contractor is going to meet the climate change requirements. Now, this can be provided by the bidder as part of its submission, and then it can be assessed as part of the tender assessment. If, on the other hand, you don't want to do that, it's not mandatory, you can ask for those to be provided within a fixed period of time after the award of contract. But using it to assess at time of tender could be quite a fine way of doing things. And of course, that is the time, if you're asking for those at the time of tender, when you might start a discussion about whether the climate change requirements you've set are sensible and right. This is a management tool again. So what this does is to spell out what the contractor intends to do in terms of meeting climate change requirements as of today. And the contractor could change that because something's happened which says, well, if I do it this way, it'll be better, or I need to do it differently because something's gone wrong. So the climate change plan will change. So the project manager can say, look, it's not working right. It's not meeting these requirements properly. Let's change the plan. Please give me a new fresh plan. Or the contractors can simply say, I've decided the better way of doing it is this. So they can introduce a new plan. So this is a management tool of monitoring what's going on, what's going to happen. The performance table is going to be quite crucial because this is the place where targets are set to incentivize performance. Now, again, the performance table will usually developed and set by the client. There can be some discussion over this and question as to how that's going to work. And of course, the targets can be changed in certain circumstances. So the targets relate to the works what work is done, but also how the work is done. So you've got a range of different ways of spelling out what the targets are. So this is my point again about NEC's philosophy of being flexible in terms of giving your clients opportunity, contracted parties opportunity to do things in a very sensible way which meets their requirements. Now the targets can be negative or positive. So you can have a payment to the contractor for achieving a target or a payment by the contractor for failing, and you can place limits on these incentives. So you can put a cap on the amount of money the contractor could pay, but equally you can put a cap on the benefit the client's going to pay the contractor for achieving targets. So again, it's a point there is that it provides this level of flexibility. So some clients will be very mature in their development, how they've developed their climate change requirements. Other ones may be right at the start of the journey, and therefore they need something simpler. So this gives you the flexibility to meet all of those particular positions. We need to report on the performance. So there'll be a regular report on how we're doing. Have we met the performance requirements? Are we meeting the performance requirement? Are we expected to meet them based on current forecasts of what's going on? So you look at what's going to happen in the future. If there's a danger you're not going to hit the target, then you take corrective action to overcome the problem, deal with it so that you know what's going on. I could just touch on here that, of course, this now fits with things like the early warning system. So now early warnings will be given if you've concern about failure to meet a target. And of course, then you have a meeting to sort out, well, what's the problem? Why are we failing to meet? What are we going to do to achieve it? And we get on with it and do the extra work, which could be a change. It could be a change to the way of working or whatever, but it's this thing that you will decide what to do, and the action will be taken to make sure you do meet the target. And I say the incentive is paid when the target is required to be met. So if it's a time, the target will have a time when specified that you're going to measure it. And if it's measured at that time, the target performance measurement is paid at that time. You don't have to include incentives. You can use a performance table simply to measure performance and record it and see how things are going. So in early stages of development of this, you might want to just not be paying any extra or penalising the contractor for failure. Just see how it's going and see what we can do, ready for the next project. So it's part of your learning process. Again, it's part of this question about whereabouts on the journey the client is. Things can change. We've got things called compensation events. You all know about those. We've got acceleration. We've got acceptance of defects. All of these things can change the amount of money that's being paid, could change the time as well. But we need to think about what the impact of those changes are on the performance table. If a major event has happened which makes achieving that performance much more difficult, you need to change the performance table to recognise it. So that's put in there. And now again, in terms of the collaborative approach, we've got a clause there which encourages the contractor to put forward proposals, something that will improve the impact of the works on climate change. So the contractor's incentivized to find ways of doing things better to achieve improved climate change requirements. It can be in terms of creation of an asset, or perhaps the contractors making a recommendation which say, well, not me, I won't do it, but when you come to operate this asset or when you come to decommission it, you're going to save carbon by doing things now in terms of how you construct it. So those things are up for the contractor to propose, contractor project manager discuss and decide. Final one on cooperation. Collaboration, yep, collaborator. There are other people involved, what we call climate change partners, and the contractors collaborating with those, working together with those to make sure that we do things the right way. Early warnings, I've mentioned, we give early warning of a problem if there's something going to affect whether we're not going to achieve a requirement, give an early warning of that. And then disclosure, providing information, making sure that there's information available rather more widely about how things are going, which can then be used by others to help them develop their ideas as well. So a bit of openness required there. You want to know more about NEC X29 clause? There's a link there which you can find. Click on that and it can bring up more information about X29 and tell you about more that you might want to need to know. So thank you for your time.
Thank you very much, Peter, for that presentation. It was good to see the flexibility in the NEC clause and also the complementarity between the FIDIC carbon management guide and the NEC clause. So I am looking to Fanny and Ondine in terms of how much time we have for questions. I know we're over time. So over to you.
Mike Hunting, you should all know who I am from earlier. A question to all of the panel. I think all of this is really good, and it's helping set the framework to be successful in this space. How much appetite do you see from clients and from people at the market that you've engaged with to achieve the benefits of this compared to a couple of years ago? Because my experience is that a couple of years ago, there's much more ambition around it from individual clients. And now it's kind of slipped down the agenda. So we're seeing in the investment world that ESG funds, there's a big uptake in ESG funds, and then it's kind of dropped back a bit. So I'd be interested in what you've experienced in the market.
Okay. From contractor perspective, I would say that the appetite now is increasing again. Our experience as we bid around the world is that this new approach, both on sustainable parameter, but in the context of collaborative delivery model is increasing. We have been monitoring. We've been experiencing stronger requests on increase in the US, for example. In Australia, has been already mentioned. They are quite familiar with this. With this, so I would say that it's increasing again.
Just a thought on NEC. What we found is that there's been a tremendous growth of interest in this since we published the clause. There seems to have developed a large appetite within the industry for taking this on board more. So it may be that we in the industry, we need to produce the stuff that people need to make it work. I mean, as an example, we've got a working group set up in UK now, trying to find the ways of developing the tools that you need, things you need to put in the performance requirements, performance table, trying to help to develop some ideas on that one.
I mean, I think one of the important things is to follow the money, look what the interests of the development banks and the international financial institutions are. They are leading the drive for a variety of different tender criteria, and that always includes sustainability issues. So it's there.
Yeah, I have a question. The David Mosey, I'm speaking. I don't think anybody can achieve improvement on the climate change front in isolation on a project. It has to be in collaboration. And I remember delivering a seminar to a major firm of engineers who said, well, we're on government projects and we've got these clear and very demanding net zero targets, but we're not connected to the contractors who are going to deliver those. We're not connected to the specialists. We're going to be punished because we can't work this out. So the theme of collaboration is well linked to sustainability. And modern methods of construction, I think, is one example. To reduce carbon impact, off-site manufacture is, I think, a major potential contributor. So I suppose my question is to the panel: how do you see the technical innovations that are necessary to deliver, or do you see technical innovations as a major factor in delivering net zero and improving sustainability? And how do you see the link between the different players being underlined in order to make sure they do it together and they're not each in isolation?
Well, I seem to have the microphone. So the answer to the first question is yes. Technical innovation is absolutely fundamental. And one of the things that I've learned so much from as part of being part of Task Group 23 is learning about all the technical innovation that's going on within the contracting firms and the engineering firms who make up TG23? And the answer to the second question is, I think, something you've all been talking about is early contractor involvement at the very early stage in the process, talking to people, understanding what can be achievable. And it's not just contractors, as you've highlighted, often the most technical innovation, I know that's not a word, but hopefully you understand what I mean, comes from specialist suppliers, specialist organizations, and they're the ones who are doing the really, really, upfront and innovative stuff. And you need to involve as many people as you can in the conversations.
Yes, we'd recognise the need for this in our X29 clause, and I touched on that in my presentation there. We've got climate change partners and an obligation to collaborate with those people, because we certainly understand the need for working together. So as well as the other tools which are going to promote collaboration, we expect it to happen on the climate change issues.
Yeah, just I of course agree with my colleague, but about innovation from contractor perspective, for sure, innovation will be a competitive advantage for contractor in sustainability, in also improve our possibility to get new contracts. So there should be it's sometimes it's like this, but there should be a clear advantage, a clear incentive for contractor if we invest in technologies. But I'm also thinking of new training. We were talking about net zero clauses, so train new contract manager generation in measuring, reporting, deal with contract. This will be an investment for contractor, but also new technologies which can reduce from the beginning the carbon emission. All of these technologies investment has to be recognized from client in order to incentivize contractor to invest more and more in this.
Yeah, one more question.
Roger Fisselson, if you can be in full agreement on the what to do, maybe we have to think collectively how to do, and the effort for training of the people, employer, contractors, subcontractors, suppliers to deliver the information needed to put in place the recommendation, which are fully in agreement with. Maybe collectively we have to think about how to do this.
I think that's a great point to end on. And I'd like to thank our three speakers who have definitely provided us with solutions today. So please joining me in thanking them.
Thank you, Juan, for moderating this session. Thank you to all the panelists. So we will now move to our third session. As you know, CICA and EIC have an excellent partnership with the DRBF, Dispute Resolution Board Foundation. So I am very honored to have Yasmin Chetinel to moderate this third session on dispute avoidance and resolution. So Yasmin, you can. Yeah, I will do for you. Do you think we need to? Okay, the crowdest panel and the latest panel. So, hello everyone. This is Yasemin Chetinel. I'm the past president of the RBF Region 2 Board of Directors. And today's last session is on the best practices on dispute avoidance, which goes with the overall theme of collaborative contracting. And indeed, it concludes on as to how to avoid disputes in continuation with the best practice in collaboration. I have a stellar panel. So first, I'm going to introduce them, and then I'm going to very briefly explain what we intended in this session, and then I'll leave the floor to them for their respective presentations. So I'm just starting with well, I think we have done it in that way as well, in the order of speeches. We have Jeremy Glover, who has been in the previous panel as well. He's the executive board president in the RBF and also partner in Fenwick Elliott Law Firm. And he's going to talk about the joint position paper of CICA, EIC, and the RBF on the current issues and recommendations for dispute board processes, which was the final product of a very fruitful cooperation within this year we made between 3 institutions. And we hope to make it a regular collaboration, an annual regular collaboration. And then we will have FIDIC representatives here. So Daduna Kokritsi as legal counsel of FIDIC and Vincent Leloup as the contracts committee, as Vincent also has some prior presentations during the course of today. They are going to be talking about the FIDIC guidance note, which is, of course, a very prominent and leading paper in the dispute avoidance. And they are going to discuss the content and the recommendations therein. We will then, so this, the first session, let's say, within the session, will be an institutional approach from 2 institutions. And then we will continue with some practical insights from contractors in practice. How we will do that, and we will continue with Marnix van den Berg, and he's in the EIC's working group for contracts, as well as he's the legal director in dredging and infrastructure in Van Oord. And he will be providing us a case study from the contractor's perspective as to how to avoid the disputes. And we will see it in practical terms, the theoretical knowledge we are talking about, how we put it in practice. And then lastly, we will have Jean-Christophe Bart-Coulard. He's representing an institution as well, a World Association of PPP Units and Professionals. And in line with that representation, he will be talking about the perspectives on mediation on long-term infrastructure projects. And naturally, of course, there will be the element of PPPs in it. Without further ado, I think I shall give the speakers the floor, and I will be sitting somewhere because we don't fit here. Okay, Jeremy, the floor is yours.
Thank you, Yasmin. And it's my pleasure to introduce to you the CICA EIC DRBF paper that Yasmin has talked about. Enhanced efficiency increases the value of dispute boards, but also it specifically aims to address the practical challenges facing the implementation of dispute boards. And I'd like to thank everyone within EIC and CICA who have contributed to this, to the work producing this paper, particularly within the contract committees. Now, the DRBF, our primary purpose, we're dedicated to the effective implementation of dispute boards. So this type of collaboration is very, very important to us. And it's particularly important that we're able to collaborate with industry organisations such as CICA and the EIC. They can bring industry perspective and experience to help us come forward with proposals and ideas to encourage the adoption of dispute boards. Now, if you don't know, a dispute board, it's a team of neutral construction professionals. You put it in place ideally at the beginning of a contract, and the DB's there to intervene early, offer advice, offer guidance offer conflict resolution strategies and try and offer them promptly to before disputes arise and before disputes become a barrier to progress of the project. And dispute boards have been around a while. We're coming up to the 50th anniversary of perhaps the first dispute board, the Eisenhower Tunnel in Colorado, and it came in two bores. The first bore, the first dig, total disaster. It was late, cost a huge amount of money. There were a lot of claims, $50 million worth. So the Colorado Department of Highways thought something had to be done. What they did was introduce a dispute review board. It was made up of 2 engineers and 1 lawyer. And when people were reflecting on this first dispute board, they looked at it and they thought, well, the biggest problem with the second bore for the dispute board was their first 2 years, there were no problems. So 2 things changed this, differences between the first bore and the second bore. First bore, parties wanted to learn from their experience and make sure it didn't happen again. And second, they had this independent neutral body with them, guiding them, helping them to avoid disputes. So the key concept, key features of dispute boards in moving on to 2024, collaborating with the parties, helping to avoid disputes, dispute avoidance, holding meetings with the parties, the opportunity to offer opinions or non-binding recommendations. But if disputes arise, the idea is that you resolve those disputes in real time. Don't store the disputes up to the end of a project. That's when it gets super expensive. You end up in arbitration and all the time and cost consequences of that. So the first question the paper thinks about is, well, do dispute boards work? Now, the simple answer is to go back to the very first dispute board and use that as your example. But there's been other research. The Florida Department of Transportation. Now, what's very interesting is that they analysed a number of projects, and they were able to compare projects with dispute boards and projects that didn't have boards. And for the projects that had a board, the time overrun was 1.8%, but it was almost 20% on projects that didn't have a board. And there were cost savings too. Typically, a project might cost 12% more with a board, 18% more when there wasn't a board. And the facts were obvious. And this is why for the past 25 years, the Florida Department of Transport has had dispute boards on all their projects. The DRBF has carried out its own research some sort of 5-6 years ago. 2 members, Jeff Smith and Leo Grutas. They found that 85 to 95% of projects where you had a dispute board, there wasn't follow-up arbitration, there wasn't follow-up litigation. And parties were pleased when the dispute board was able to operate in a dispute avoidance manner. So the suggestion was that dispute boards work. And currently, King's College London have been carrying out some dispute boards, some research into dispute boards, and they're going to release their formal report on the 9th of December of this year. So look out for that on the website of the Centre of Construction Law and Dispute Resolution at King's College London. And they've studied dispute boards over the past 6 years. So from the date beyond the DRBF research, most users have found dispute boards useful in avoiding disputes. But very importantly, subsequent proceedings only commenced well under 10% of the time. And also, the final decision of the arbitration tribunal rarely any different to the decisions that the dispute boards were coming up with. And cost, often put forward as a barrier to the adoption of dispute boards, total cost no more than 0.5% of the total cost of the project. And that was bang on with the research, the same as the research carried out by the DRBF. So that's part one of the paper that has been put together. The other part, and the part that had particular input from CICA and the EIC, was thinking about the challenges to the implementation of the dispute board. What were the barriers? What was stopping dispute board? And there's about about 10 examples given in the paper. So I'm just going to highlight 2 or 3 now. And it's not just what the challenges are, it's looking for solutions. So sabotage. Parties, for whatever reason it might be, aren't convinced about the value of dispute boards, and they'll undermine the process. They'll try and make the appointment of a dispute board last months and almost years to prevent putting a dispute board in place in the first place. Now, I think 2 things here. 1, research, cold, hard facts. Now, some of that already exists, and more will exist at the end of the year, but also education, targeted education to make sure that people understand the value that dispute boards can bring, and also make sure that you have experienced dispute board members who understand how to help bring those benefits to the project. Lack of geographical diversity. Say I was appointed to a dispute board in South America. How would I effectively and neutrally understand the local contractual issues, understand the cultural considerations that come into play on a South American project? Well, I probably wouldn't. Now, so you wouldn't want to appoint me to those particular dispute boards, you might think. So one of the solution is, well, make sure that at least one of the dispute board members comes from the region, not necessarily the country where the project is, because we're talking about neutrality. Make sure when you're thinking about who your dispute board member might be, to ask them what their experience is. If you ask me, it might turn out that I actually do have experience of working in projects in South America. So I might not be the poor choice you all might have thought. But the other thing is, if you have a standing dispute board, you put your dispute board in place at the beginning of the project. One of the things they do is use the time to get to know the parties, to understand what makes the parties tick. But what they can also do, and I would say what they should be doing, is taking time to find out about local culture, local customs. How does that impact on how the project works? Lack of borrower compliance. The other thing that we've done with CICA and the EIC is discuss the report with representatives from a couple of the development banks, because development banks think dispute boards are a good thing. And one of the issues you find is that the development bank says you should put in a dispute board, and it doesn't happen. So how can we stop that? You know, we can ask the dispute boards to be tighter about their processes. There can be some difficulties with that. But, you know, again, education, procurement teams of the development banks. To what extent can the banks and the funding institutions prevent borrowers from getting round their obligations? They've signed up to funding agreements which says there should be a dispute board. How can we actually encourage them to do that? Delays. Talking about real-time resolution, talking about being prompt in putting forward ideas to put strategies in place to stop disputes emerging. And that's why you need qualified dispute boards dispute board members who understand how the dispute board process works. So you need to expand the pool of trained, competent dispute board members. And that's something that FIDIC have been doing. It's something that the DLBF tries to encourage and will help. If you want people to be trained, we will help you to do that. But then, because there's an obligation on dispute members too, they're a key part of the process. They need to make sure that they are available for the duration of the project. It's not just being available for the next 6 months. They need to be available for the next 3 years. So think about the questions that you might ask if you're looking to appoint a dispute board member. What are their schedule constraints? What are their schedule constraints really? How many other projects are they actually sitting as a dispute board member? So the things that you can do as party representatives to ensure that you get the right dispute board for your project. And you need to think about what you're asking the dispute board to do. Do you want them to have the power to make recommendations which are not binding? Or are you looking to give them the power to make decisions which are binding on a temporary basis? And that may depend where in the world you are and what your experiences you are. But again, it's thinking at the beginning of the projects, what works best for you, what works best for all the parties who are part of the project. And the final part of the paper, some actions that DRBF, CICA and EIC we propose. You should be looking to impose standing boards at the commencement of the construction contract. Increased education, fundamentally important. Continued education, equally important. Cover the cost of the DB. It's small, but include it and identify it in the project budget. Continue to increase the pool of potential DB members. Remember the value of conflict and dispute avoidance, which comes with collaboration, which is one of the key themes of this conference today. And I think we should be looking to promote further research. I mean, the bottom line, I mean, putting it as simply as I can, parties don't want to get in a fight. Parties want solutions. Using a dispute board is one of the best ways to help the parties get those solutions. Thank you.
Good afternoon. Thank you for the opportunity to speak today about the important role that the dispute boards do in avoiding disputes. As Vincent has mentioned this morning, we will not be talking about the role of the engineer, which also has the role of dispute avoidance under FIDIC contracts, but we will concentrate on the dispute board's role in dispute avoidance, focused on their dispute avoidance function, and will present the practice note that FIDIC has produced in this respect. In construction and engineering projects, and Vincent will be joining me in this discussion after we move to discuss the specific tips and tasks that we have set out for dispute board members. In construction and engineering sector, avoiding disputes as early and as quickly as possible is in the best interest of the project, in the best of interest of the parties and of the funders and all the participants. For the reason, FIDIC contracts provide for the standing dispute boards, and it includes the dispute avoidance provisions in its contracts. It was first introduced in 1995 in FIDIC Orange Book, and it has then evolved in different FIDIC forms of contracts. In 1999, it was included the standing dispute boards in FIDIC Red Book. It was followed by the harmonized copy in 2005 and 2010. In 2008, FIDIC Gold Book introduced a separate clause which was specifically dedicated on the dispute avoidance function. And since these clauses have been evolved, and in 2017 suite of contracts, in all three contracts, appointment of dispute boards became mandatory on in all three contracts, and also the contracts provided for more enhanced dispute avoidance provisions. In 2019, FIDIC recognized the appointment of dispute boards as one of its golden principles. So what we'll be talking about today is what I have noted from EIC position on collaboration delivering models, which is golden rule 10 identified to be the agile on-site dispute resolution. So this is what FIDIC contracts with its dispute avoidance and all the claims management do in its contracts. Now, in recent years, FIDIC has taken additional steps to raise awareness and promote effective use of standing dispute boards and the dispute avoidance function, as I've mentioned. And one of the key initiatives was to establish the FIDIC Dispute Avoidance and Adjudication Forum, which serves as a platform to bring together the dispute board members, the contractors, the other practitioners as well, to discuss and promote best practices to see what actually works in practice practice and what are the challenges that are seen. And as part of the Dispute Avoidance and Adjudication Forum, which FIDIC now holds twice a year with its Global Infrastructure Conference and the Contract Users Conference, FIDIC produces practice notes as part of the discussion and as a follow-up of that, in order for those documents to be used more widely on sites, on project by project participants, and not to remain within the forum discussions only. So as a part of that, FIDIC has created a small working group which set out some questionnaire that was distributed with 110 dispute board members of the FIDIC's president list, to ask the following 5 questions, which are on the screen, which is more like a practical: how, when the dispute boards make aware of its dispute avoidance functions, what are the matters that the dispute boards could actually look at to help the parties in settling, and where should the dispute avoidance take place, in what form. So all the practical questions that could be then identified. We have received around 34 responses. We've analyzed them and discussed them in the dispute forums, and subsequently produced the practice note, where we've identified 5 tasks for dispute board members, which we believe that, if followed, will help in successful avoidance. But before we start to discuss the specific tasks and tips that we've set out in the practice note, which I'm holding here, and like to mention that the practice note 1 is available for free download on FIDIC website. So if you are interested, you can have a look at it in detail. I'd like to say a few words about the benefits of dispute avoidance. And of course, one of the major benefits for it is to avoid the ability to clear differences at an early stage. This is the key benefit, because by addressing issues proactively rather than allowing them to escalate, the dispute avoidance really helps disputes from piling up, and it also reduces the stress on the project participants, and direct the project participants' attention to actually delivering the project rather than dealing with claims, issues, and disputes. So that's a very key benefit of dispute avoidance. It also maintains the business relationship with the parties and gives them the ability to continue and also to work on another project, because rarely that you would see 2 parties going into a big arbitration fight and then having a successful second project. If any of you have that in practice, it's probably a step forward, but it's really doubtful. So that's a key benefit to dispute avoidance. But there are main obstacles as well that we've looked at, and understanding those obstacles are important in order to create the environment where dispute avoidance can actually work. And one of the obstacles being identified to be for example, pressure on government officials, for example, the pressure of audit and the scrutiny and accountability, in which case sometimes government officials feel more comfortable to go into litigation or arbitration or to settle disputes later rather than to have the dispute avoidance exercised, and that might be due to the reasons of accountability or scrutiny later on. So, and creating the environment where the dispute avoidance works for all the parties is key. Another obstacle to exercising this role successfully is what Jeremy has mentioned, is the availability of dispute board members, because, for example, scheduling a site visit down the line after 4 or 3 months when the issues are already there might not be helpful for the project, as they have to be avoided as early and as quickly as possible. So creating the capacity of dispute board members is key. So for that reason, FIDIC is working with the FCL, as Vincent has mentioned, to increase the capacity of dispute board members. The RBF is, of course, also working on that and asking a real question whether the dispute boards have availability to serve on the project is important. There are other pressures and obstacles, for example, the deadline to open the project or to deliver on time. So, but the good news is there are some drivers that can be exercised successfully and that can help the dispute avoidance, which can be really achieved by proactive approach by the dispute board members, by the parties themselves as well, because dispute boards can do nothing alone if the parties are not set with the mindset to be avoiding a dispute. So adoption of early warning mechanisms that's been also discussed this morning is key in giving the board's ability to understand what are the issues that exist on the project in order to be able to address them effectively. And with that, I'd like to set out 5 tasks, which we sought after the discussions are key, and or the tasks and techniques given to dispute board members. If exercised, we think will deliver successful avoidance of dispute. And those start with task 1, which is to raise the parties' awareness on the dispute board's dispute avoidance role as early as possible. And I'd like to ask Vincent to lead us through a little bit into practical examples of how actually the dispute boards can achieve that objective on projects.
Thank you, Leduna. Yes, for this first task that we recommend the dispute board to undertake, it's to talk very early from the appointment stage to the parties about the dispute avoidance features of the dispute board, because very often parties, in my practice as dispute board member, the project team members you have around the table are not necessarily aware of this dispute avoidance feature of the dispute board. And often you find parties who are actually thinking that the dispute board is only there to step in whenever you have a fully fledged dispute already in place. And they do not necessarily have in mind that you can help them avoiding having a dispute to arise in the first place. So I always start with, in the kickoff meeting with the parties after appointment, whether the kickoff meeting is online, if I'm located far away from the project site, and so as to save cost for the parties, we do that online. If I'm located close to the project location, like when I sit on a dispute board in France, then we organize a face-to-face meeting and I present them the dispute avoidance feature of the board, telling them they can ask me for informal assistance, opinions, non-binding, and at any point in time. Second task we recommend dispute board to do is for each and every site visit. You know, they do site visit every 3 to 4 months. Put a clear agenda item for discussion about matters of concern, issues arising between the parties. For the first site visit, generally what I find is that when I ask the parties before the site visit about what are your issues that you want to talk during my next site visit, often I get no response and no one dares say anything. So that's not necessarily a surprise for me. Then when I go to the site visit, I then try to break the ice and make them talk about their issues, especially if they think that the dispute board is only there to deal only with disputes. So when they understand that it's also there to talk about dispute avoidance, it's a good opportunity to discuss those issues. The advantage also is that you have a third-party person that hopefully you have trust in, and therefore this dispute board can allow the parties to have a disciplined discussion, not a heated one, because of course they discuss in the presence of a third party. So somehow that also helps in terms of the conduct, and that can help the parties to discuss in more details about their respective points. And finally, for the dispute board is also to keep a dispute avoidance radar on. You get monthly submissions from the parties, monthly progress report, IPCs, list of claims, list of variations. With all that documentation package that you go through every month, you can identify issues which are typically poisoning the life of the parties on the job. And then as a dispute board member, you have also the capacity to proactively go to the parties and say to them, hang on a minute, I see that you are struggling with this instruction of the engineer for months. The contractor considers it's a variation. The engineer and the employer consider it's not. If you want, I can give you a non-binding opinion as to this. So some very practical tips in this respect.
Indeed, Vincent, and sometimes as well, just a simply knowing by the parties that the dispute board has a dispute avoidance function, they can ask the questions and receive the answers is key. Sometimes the parties, if they take up the contract, may not be even aware that we had questions like how the DB can do that. And that moves us to another task that we've set out, which is building and maintaining trust with the parties. This is one of the key elements for the dispute board in order to be successful either in dispute avoidance or also dispute resolution function if it comes to it. And there's been a few tips proposed for that, that the success of the board would really depend on the trust and confidence that the board creates with the project participants. And by demonstrating a few qualities of the dispute board, this can be, we believe, achieved. And one of the key qualities or two are the demonstrating independence and impartiality, which is a requirement for the members of the dispute board. So dispute boards should make it clear to the parties that they are independent, they are impartial, and also that they have the best for the project approach, so that in order for the project to be successfully delivered, they remain neutral and would give the opportunity to each party to present their case. Very important is effective communication. As a practical tip, the dispute board members could set out some communication policies at the outset of the project and establish how the communication could flow successfully with the project participants that would allow them to exchange information effectively. And important is for the dispute board members to have the respect of the parties by remaining calm, listening to the parties, and by active listening, actually to demonstrate and to show them, whether through the opinions or decisions, that the parties have been listened to and understood in the opinion that the dispute board members give to them. Well-reasoned opinions are very important, so that each party understands where the dispute board is coming from, whether that's done orally or in writing. There have been some other key qualities discussed as well. It was proposed that the dispute board members should be charming and charismatic, but finally we did not land that on that. We thought that if the dispute board possesses the qualities of independence, impartiality, good communication skills, that it's set for the success for the project. So, Vincent, unless you'd like to add to that, or we move to the next.
No, I think it's okay. But it was a bit difficult to put that in black and white, yeah. But in fact, what we wanted to avoid is the ego maniac, which we can have in our profession and like in any profession. But of course, you need to have some ego to drive the process properly, but not too much so as to be going against your dispute avoidance duties.
Indeed. And next task, and these tasks are not in order, they are complementary to each other, so the numbers have no, of course, no relevance chronologically. So the next, and very important, is to determine, to identify and to communicate, to determine, actually the most important that I think is task 4, but we're talking about the task 3 now, and we'll move to, maybe Vincent, you can
I'll do that in a row, yeah.
Together in 10 benefit of.
Yeah, because we are in a critical delay and we have no float, so we have to accelerate the rate of progress. So determining when and where dispute avoidance should take place, of course, site visits, but not only. As I said before, once the parties realize you can help them with dispute avoidance during site visits, sometimes they think that you can only do that during site visits and that's it. So then they keep on the side everything for the next site visit. And of course, it can happen between with email communication, with online also meetings with the parties, which can be easily arranged. Claim dispute process also, the earlier the better. To have the dispute board to step in, especially if you see that there is a blockage on the way to try to reach an agreement on a claim. There might be threshold questions in terms of liability from arising between the parties. And you can have a surgical approach of the dispute board, just jumping on a key question, which is right now blocking the amicable agreement path, and for the DB to give an opinion. And also, better than me that it's human nature that if you have kept on arguing for one position for months or even years, it's very difficult for you to go away from that position. So you have the risk of becoming entrenched in your own view. So the earlier a third party can give you an opinion, the better, because you still have some mind flexibility to consider something else that you have considered so far. Then the next question is early, nice, but maybe not too early, because sometimes we see also that once the parties are liking the dispute board avoidance features, they tend to go to the dispute board even before they started to discuss about issues amongst themselves. And of course, the purpose of the DB is not to replace the project participants. So we always encourage the parties to discuss first between them, employer, engineer, contractor, and only if and when they see that they cannot reach an agreement, they can turn to the DB. For matters which are ripe, appropriate for dispute avoidance, there are a few of them, so you can give on the spot opinions during site visits that can be fairly neat and quick for contract interpretation matters. We always have a lot of differing views as to how to interpret contract provisions. So when it's a FIDIC form of contract, some people, for example, believe that in the 99 edition, the submission of a fully detailed claim is subject to a time bar, which is not the case. It's only a directory obligation, not a mandatory one. The usual suspect of request for opinions from dispute board is whether an engineer's instruction constitute a variation. I think I have it on all of my dispute board that always come at some point in time. Discussing early about the procedures also. Variation procedures, claim procedures. Does a variation require an amendment? Can you trigger a variation before having reached any agreement on time and price impact? All these kind of things. I always tend to push the parties to ask me for a discussion about that from the very early stage of the dispute board proceedings, because you always find out that people have differing views, and at least it can set the right tone and the right procedure going forward from the start. The merits of a claim, also a good candidate for opinions from dispute board. Design responsibility and liability, that's another one. What burden of proof do you expect on a particular claim? And also, I would say probably even more importantly, standard of proof. This is where you see a lot of various differing expectations, especially on the engineer side, expecting to get a claim detailed and substantiated down to each and every bolt and nut. And the notion of standard of proof is sometimes not very well understood. And plus, of course, threshold questions that are blocking the parties in an attempt to reach agreement. A classical one is whenever you deliver a piece of work and that piece of work is not covered by any BOQ item, and then you wonder whether a new BOQ item should be created. That's also something which is coming up quite frequently.
And the final task, and there are many tips in the practice note which can be read, of course, and Yasmin will forgive me for 1 minute to talk about one final task, which is to identify the best form for dispute avoidance. And what is important is to consult the parties and in each process, as informal assistance and dispute avoidance is a joint request of the both parties. So understanding whether the form should take in orally or it should be in writing, because there might be some circumstances where a quick opinion could be helpful, which is given on site orally, or it might be more helpful to have a written opinion, which the parties or either of the party can then use to substantiate their view or to better even understand what the dispute board's recommendation in this respect is. So consulting the parties on the best form and actually finding the best way to deliver that informal assistance is key. And I'd like to finish this with saying that we've been talking about the dispute avoidance role of the dispute boards, of course. We didn't talk about the dispute resolution or the decision role which it comes, and also did not talk about the important role that the engineers have in dispute avoidance and other elements that are built in FIDIC contracts that facilitate the quick on-site resolution of issues without them escalating to arbitration or to even stopping them before they go to dispute boards even for the avoidance function. So because as we said, the note is concentrating on the board's role, but we hope we'll have some opportunity to talk about it in some other time. So thank you very much.
Thank you. So after setting the scene for the theoretical and the study-related input from two institutions, now we'll see a case study from a project, from a site. Let's put it in practice.
Good afternoon. I have a train to catch at 4, so I'll try to be brief. What I'll present today is a case study from a project where early contractor involvement was used and where the DAB played an important role in resolving disputes during project delivery. Unfortunately, because of reason of confidentiality, I have to present it on a no-name basis, but it's a project situated in Central America. The scope of work was reclamation of an artificial island and the construction of a container terminal on top of it. The client had put it in the market as a two-stage early contractor involvement thing. It was competitive. So there were two contractor consortia that were pre-qualified and that were invited to the first phase where the, let's say, the reference design had to be completed with clever solutions. So the two competing contractors had to come up with cost-efficient, cost savings, and a very constructible design. One team was working together collaboratively with the employer and the designer in Houston, and the other team was working collaboratively with the employer and the designer in Philadelphia. This phase was recorded in a memorandum of understanding. The idea was to develop cost-efficient design solutions in collaboration. Design then had to be endorsed by the designer because he had the ultimate responsibility for the design. The MOU also set out a number of general deliverables. The most important one was construction of the second phase to be completed in no more than 30 months. That's 2.5 years. There were also specific deliverables, and in that phase one, the contractors also had to finalize their price. Okay. The client then was going to award the works phase two on the basis of 3 criteria: price, 70%, schedule, 20%, and then general completeness and responsiveness to the tender criteria. The first phase was very, very collaborative. Everybody was really happy with the way the contractors collaborated with the designer and with the employer, and they wanted to continue that. So I worked for the winning consortium, and we wanted to continue that in phase two. Now, the client wanted to have a FIDIC Red Book 1999 with particular conditions. And FIDIC isn't really known for its collaborative principles. So what we then decided to do is try to capture that collaborative spirit and put it in a contract appendix, which we very originally called collaboration principles. Now, we pinched some ideas from NEC. And we used wording like that we even said utmost good faith, spirit of mutual trust and respect, encouragement of collaborative behavior, taking appropriate action when someone was not behaving collaboratively, and in general, the creation of an environment for providing reciprocal feedback and sharing of information. Okay. We also introduced the risk reduction meetings. That came from early warnings. Whenever events happened, circumstances occurred where we were going to lose the critical path, then parties got together, set up a meeting to discuss and agree on a way forward. We even mentioned how to deal with concurrent delays, and we introduced the concept of senior executives committee, where if a party was dissatisfied with an engineer's determination, this could, before it was referred to the DAB, discussed and potentially, hopefully settled by the senior executives. Okay. Now, typically very collaborative during phase one. In phase two, different people came in. The designer became the engineer administrating the contract, but it was different people. Different people from the client, different people from the contractor, different people from the designer/engineer. and the collaborative atmosphere just evaporated. Okay. We as contractors, we thought, okay, this is going to become contentious. At some point, we'll need a third party to decide on the disputes. So the contract provides for a standing DAB. So why not start a standing DAB? Why not establish it? The client then says, well, standing DAB, I'm not so sure. Let's just appoint a DAB when we have a dispute. I said, no, the client provides for a standing DAB. So this is the first member we're proposing. So we started the process and we found a civil engineer who was also a barrister. He's an arbitrator and he's very familiar with marine construction works, very impressive CV. That was our proposal. Client accepted it. The client then proposed a soils expert with no dispute resolution experience whatsoever. And he said, and he's going to be the chairman. And the DAB member that had already been appointed said, well, if he's going to be the chairman, I'm out. So then, so the client then came up with another CV, a lot better, and that was a retired judge from the Technology and Construction Court, High Court in England. We saw his CV and it was quite impressive. And actually the reason why the client chose him as a potential chairman was that in one of his landmark decisions, he had vividly applied the experienced contractor test. So the client thought, he's going to be tough on the contractor, that's our man. So we accepted it, as I said, and then the third DAB member was appointed, also a lawyer and an arbitrator, very experienced, and this is what he ended up with the standing DAB, which was quite a legal and a legalistic, lawyerly DAB. Okay. I talked about the selection, so then we had to put things in writing. It was the agreement where just DAB members were individually appointed, where you agreed on the retainer fee, the fee for adjudication work, the fee for site visits, for travel costs and whatsoever, and so on. Then we had the general conditions of dispute adjudication, just mostly copy-paste from FIDIC, and an annex with procedural rules. Those were 9 procedural rules, also relatively standard FIDIC template. As soon as all of that was signed, the chairman, who was a very active chairman, came up with an additional protocol on procedural matters with very, very detailed procedures on site visits, what kind of documents he wanted to see, how site visits should be organized. And he also set out very detailed rules on dispute adjudication, nice timetables, how the submissions should be formatted, how to deal with evidence, how pages should be numbered, how really very, very detailed, and also how hearings should be conducted, how you cross-examine a witness. Even he didn't go as far as deciding on the dress code, but it almost went to that level of detail. Okay, so this is a timetable here. So the let's say the prescription from FIDIC is to come to a decision within 84 days. This is a timetable he proposed, and which we accepted. And the interesting thing here is that before the submission of the statement of case, there is a 3-week period. First, there is an informal pre-notification, and then there's a notice of referral. And why is that? Because the DAB didn't want the respondent to be surprised. So in the informal pre-notification, you identify which disputes you're going to refer to the DAB. If you're going to rely on expert evidence, if so, in which technical area. If you were going to rely on submissions of law other than English law, because this was a contract on the English law, but it was in Central America. So to some extent, local laws were relevant. It also made it possible to bring up procedural matters. One of those procedural matters, for instance, was we had the habit as contractors, claimants, of honing our claims. So we brought a claim to the engineer in a certain format with certain arguments, and then we failed. And then we escalated it to the senior executives, and then to the DAB. So by the time it got to the DAB, the claim looked always a bit different. And then the respondent said, well, you know, this is not following the procedure. So issues like that were raised and decided before the statement of case was submitted. What the chairman also liked very much were opinions. Like you already, Vincent, mentioned, FIDIC Red Book allows for the use of opinions. If at any time the parties so agree, they may jointly refer a matter to the DAB for it to give its opinion. And neither party shall consult the DAB on any matter without the agreement of the other party. That means you don't have a claimant and a respondent any longer. You have the parties who jointly agree to bring something to the DAB. And those opinions, requests for opinions, could be about anything that is relevant to the contract. So not really crystallized disputes, but what does the contract mean, and even a point of law. It's a relatively short procedure, but it's also with responses from both sides. This, I believe, is my last slide. How did this work out in practice? Well, very well, actually. We always planned far ahead. So we booked dates in the agendas of the DAB members. They were all very busy. So we looked about 18 months ahead, and we pinpointed dates for site visits and hearings. And we made sure that these coincided because they flew from the UK, from Europe to Central America. So we had to, you know, be reasonable with transport costs and also with time. If at some point a hearing would not be necessary, then it would just be a site visit. And in practice, we as contractors submitted claims to the DAB every quarter. So and we had set up a sort of a rolling system where for every DAB hearing, we had 4 disputes that were referred per quarter. And that went very well. In fact, it was a sort of a mini arbitration. That's what happens when you have this setup of a DAB with expert witnesses, where there was cross-examination, witnesses of fact, supporting evidence, what have you, a mini arbitration. Now, how did it work in practice with the collaboration principles? Did they help? The mutual trust, well, we talked a lot. Was there an atmosphere of feedback? Yes, there was, but it was very negative feedback. So it was phase 2 was quite adversarial. The risk reduction meetings and the early warnings, did they work? Yes, but we didn't have enough risk reduction meetings because the engineer was actually quite obstructive. The senior executives, well, again, this was we felt it was sort of a delaying tactic from the employer to sort of discourage us to escalate things to the DAB. And if you read the minutes of meeting, well, some things were sorted, but more often than not, actually, the conclusion was parties agree to disagree. So that doesn't really help things forward. The DAB, on the other hand, worked very well because we had a very disciplined chairman. The decisions were always well drafted. That's, of course, his background from High Court in England. Very, very well drafted. And he drafted it for the benefit of the losing party. Winning party is always very happy that he wins, but the losing party has to understand why he lost. And that was key, in fact, in making sure that nothing went to arbitration because it was so well argued. It was well written. And the good thing is that everything was sorted before taking over of the project. So I'm actually quite happy with how it went with this DAB. It was very loyally, yes. You can choose more technical profiles for your DAB. That would have been a different DAB where parties sit together. How can we solve this? Look ahead. This was more a DAB that looked at crystallized disputes. Key takeaways for me from this case study: well, collaboration works if parties want it to work, and a DAB is a very powerful tool in avoiding disputes or resolving disputes prior to taking over. And to avoid disappointment, parties need to agree beforehand what type of DUB they want, more loyally or more technical. That's it. Thank you very much.
Thank you. Thank you very much. I think we also had the practical insights with relation to the dispute board in the dispute avoidance topic that we are discussing. Now we'll have a slightly different approach because we'll delve into the mediation as a dispute avoidance. Floor is yours, Shankros.
Thank you, and thank you to indulge for a couple of minutes so I can develop the perspective on mediation. And then if I read the energy in the room, I can see that it's still very high and that you will be patient because I'm separating you from your lunch, but that's the way it is. So I'm going to put my stopwatch on, and here we go. So I have done many different things, but I basically come from the arbitration world, and I've moved into more consensual dispute resolution because I've seen it happening in projects that sometimes it's simply not working through distributive negotiation. And typically, the bestsellers that you find in dispute resolution is, I'd like to have my cake, and I'd like to eat your cake too. Most of you can relate to these situations, and there's no success formula for that if you don't actually dig down to the interests behind the positions of the respective parties. If you're failing to do that, and you simply scratch the surface, you will have a black swan event, and nobody wants that because we know that the contingency you put into the project at the beginning often not enough to really cover the cost of big blown disputes. If we look at the array of available mechanisms to resolve disputes, I'm actually going to focus on this side, the mediation space, which is, if you look at the orange line, involving a third party on top, and at the bottom is what the parties can do on their own. Fact-finding missions, negotiating sometimes. But sometimes you need help in the negotiation process, and then it's wise to actually take a deal mediator on a very early stage, even when you're just designing the contracts, because this can avoid complications later on. And this is what I'd like to expand on with you. We've heard a lot about dispute avoidance. I think it's fundamental. Dispute boards are a great tool for that. If you can induce now some aspects of mediative posture in the dispute board, I think then it's even better. Then we can make this really a very effective tool out there. The big advantage of transformative mediation is you have amazing flexibility. If you can't agree on the mediator, for example, you can take somebody from another culture, you can take somebody from another gender. Sometimes two mediators, the co-mediation couple or tandem, can actually resolve things in a much more efficient way because they can read the emotions in a different way. But so that's a really flexible thing that I don't know many other techniques that actually provide for that. And I'm very happy to also appreciate that even within the FIDIC community, like the General Counsel, nobody less than that actually is now a trained mediator also, which I think is really positive for the industry. It's a very cost-efficient way to deal with difficulties. It helps to preserve relationships. We've heard what happens after an arbitration. It's often game over. And especially in the industry where I'm operating, in public-private partnerships, where you are engaged in 25 or longer periods of time, you can't afford to lose suppliers or other bidders. And I know also the owner side, so the state entity that wants to have contractors, if they don't find any anymore in their market, then they don't look good. And it's bad for the reputation also of that industry. Often I hear that, yes, mediation, but the settlement agreement, that's not always enforceable. Well, let me tell you, there is now the Singapore Convention, which is one of the UNCITRAL tools to facilitate the implementation of settlement agreements internationally for the signatories who have ratified the Singapore Convention. There is no European country part of it yet, but I know that the UK is considering it. The US have ratified it. Several countries have already, China also, by the way. You don't actually need the Singapore Convention, but it's good to know it exists because it facilitates things. If you still want to be sure that it's executable with a settlement agreement, you simply go to a notary public or you go to a judge and ask for homologation of what has been decided, because then it will have la force de la chose jugée, right? It will be implementable directly as a contract. And usually, you don't have difficulties in implementing something that the parties have agreed on themselves, because that's the big difference between non-consensual and consensual dispute resolution. Mediation being the prime manner to agree on something forward together. What is important to me here is organizations and cultures like water become stagnant and unhealthy without continuous movement and change. Every project has its own culture of working. And what we can do to actually help facilitate that with all these complexities here around the project is you can set up a memorandum of understanding and process. How does that look like? I have an example here in that booklet. I'm happy to show it to you, but for time reasons, I'm not going to delve further into that. But it basically makes sure that you just define how do you want to work with the different stakeholders in your project environment. And I'm not talking about, the performance metrics of your project. I'm talking about something that is extra, extra contractual, but it's so important because it gives the bond between the project teams that enables them to deliver value at the end of the day and not just propose stuff that in the end isn't lived that way. We've seen it happen in projects. It's very unfortunate if the escalation mechanisms isn't lived in the way it's actually designed by the lawyers, who often don't work on the project themselves when it actually happens. But this is why working on a MOOP that works and can be redesigned over the project life cycle is something I found very effective to do, because it really helps you to channel the spirit of the project. Is sustainable development goals something that is just en vogue, or something that we believe actually helps de-risk the project? These type of things. Climate change is just one of the hints I can give you to that. And there's actually an example in my deck here. So the perks of mediation is actually, it's channeling the collaboration. It's building that bridge that Mr. David Mosey mentioned at the very beginning. It enhances the value and the benefits to fortify that business relationship. You keep control as the parties of the outcome. Nothing is agreed until everything is agreed, and you can shape the future. And I don't know any other mode that enables you to have the same, possibility to forge a deal for the future. And that's why mediation is simply so effective as with a deal mediation approach. Nobody loses. That's also a big psychological plus, right? Because it's consensual. Both parties agree on a certain way forward. It gives you flexibility because it's a self-determined process. Nobody imposes something. Right? In an adjudication, you have an adjudicator. In an arbitration, you have the arbitral tribunal that will decide on things for the parties. In a litigation, well, you have a judge who's supposed to be independent and will impose something. And then you have to live with the outcome of that process. And that's not always something that goes down so well with the parties. It's very expensive too. Mediation has the big plus that it's also confidential. So adding a mediation cost doesn't cost anything. You can simply have it as a part of a mixed modes approach, have anticipatory mediation provided in that memorandum of understanding and process that you prepare upfront, and that you can adapt to the needs of the different project evolution phases. If we look at the whole, how does a conflict actually develop? Typically, what you see is hardening of positions. Then at some point, there's an end of communication. You start firing small Scud missiles on the other side. You will hear threats. And if you don't do that, then I will not do this. And you start building coalitions and say, my likelihood of succeeding is 98%. So often we overestimate massively the chances of actually prevailing in a case.
But at the end, it all leads to a fragmentation of the relationship, and it's very bad for the contract situation, and nobody can win because then you go into the abyss and everybody loses in that situation. At the bottom, you can see different phases: lose, win-win. Typically, here in the middle, phase 2, it becomes very difficult to get out of that hole without external help. And this is something you want to avoid, and this is why dispute avoidance is so crucial. Do we need to define conflict? I think it's not necessary. What is really important is to give ourselves the tool to properly discuss how risk needs to be allocated, especially in a public-private partnership deal. But if you want to ensure long-term performance, it's like a long-term relationship. At the beginning, the intensity is very high, right? And over the period of time, the passion tends to decrease. So if you're not able to instill some mechanism that maintains a certain compassion between the different project partners, then it's going to be very, very difficult. So statistically, the honeymoon period is of limited duration. I'm at the end of my time. I don't know. Do you want me to continue? Okay. There are different non-escalation methods out there, partnering approach. Everybody has heard about that. I think it's really important to visualize things. I'll give you a practical experience why it's important. Dispute boards are a great way to avoid that, you know, there is an escalation of things and you find a way to resolve things. Co-mediation, and worst case, you know, if you have a combined, a hybrid clause, you can still have final and binding decisions with an arbitration. So combine these tools, and then you have a really good mechanism for that. Visualization of contracts has, I believe, a very positive effect. There's a discipline called legal UX design. So if you look at the left and on the right side, who would prefer to read a contract on the right side? Hands up, please. And who would prefer a contract on the left side? Less people. Okay, good. So we know, and that is science, that contract usability and comprehension is much higher when you visualize things. Not only is it quicker to understand what it deals about with, you know, time frames and stuff, but also it gives you a more accurate number of correct responses. And this is why we have a clear benefit of taking some time to actually implement better user experience and the contract design. It's a discipline. It's been invented under Scandics, and I think there's a lot we can learn from that. It definitely helps avoid disputes. Now, with the MOOP that I mentioned earlier, we can insist on having not just better communication, I've heard that before, but very high quality communication. It's a psychological effect, but it makes a huge difference after all in the project implementation, right? Also, if you look at it from the process control, litigation, you don't have any control. You're delegating your problem away to a judge who will deal with it whenever he gets to do it. It's going to come on a stack and strictly be dealt with chronologically. It costs lots of money. It sucks away huge amounts of energy, and especially if you're in a project reality, you don't want that. You can't afford having the same key people in engineering be busy to give witness testimonies and stuff like that. Same a bit with arbitration, and to a lesser extent with dispute board recommendations. So the less invasive way I would suggest is to go with mediation, because third party doesn't intrude that much into your business operations. The success rate of mediation is astonishingly high, but it's no wonder, because it's something the parties decide to do together. It's a consensual approach to dispute resolution. So my question to you is, can you really afford not to at least try mediation? Because it's for free. You simply insert a clause, or you agree with the other side, let's have a mediation clause, and you can combine that with dispute board, with ARB, med-ARB, so you don't lose anything. I'm wrapping up. This is how the mediation process actually works. It's important you know it's simply a co-mediation contract at the beginning, depending how many mediators you use. Then you identify the conflict areas, the facts finding. You capture the needs and interests of the respective party. You try to work on joint approaches, mutually acceptable solutions. And then you do a written settlement agreement. And that's not it. For me, it's important that you also monitor that what has been agreed on is actually being done afterwards. But now you have found a mechanism to deal with adversity in a project. And that's something promising because you can build on that and develop a partnering approach over a long period of time with the supplier or with the contractor. And this strengthens the relationship. I'm gonna spare you from that, but I don't know who has heard about NVC, nonviolent communication. One person out of, I'd say, 80 people. Oh, more than that. Okay, let's say 10 or so. We don't talk about this very much in business, but having an appreciative form of communicating is so much powerful for your business success. And why, I mean, just quick question, why do I choose the giraffe with that? Any idea? It's okay. I take that one. It's cute. The giraffe is the land-based animal with the largest heart. And that is because it needs to pump the blood into the brain, right? So it has a very strong heart muscle. And it's a good metaphor to remember that you sometimes need to decelerate the way we communicate. Say what you observe, what your feelings are when you see that, what your needs are, and then you have a call for action, a request to the other side. And that's much more, I'd say, conducive for a good collaboration than if you say, based on my judgment, this will not work. Okay? It's just a way that we deal with each other in project realities, and that human factor, I think, cannot be underestimated. To sum it up, a mediator is a good performance catalyst. You want to avoid the huge cost of business disputes. I would suggest let's have a mediation first approach because it doesn't cost anything. It helps you to stay in charge of the thing. Nobody takes away the control. Nothing is agreed until everything is agreed, and it can lead to reduce information asymmetries and to mutually acceptable outcomes. I leave you with my mediation progress barometer that I developed for students at ICC. And the interesting thing is, we're in France, we like eating baguette, but this is a good way to remember how it works. Because here you have an opening statement, getting to know each other better, very high quality communication. And you move on to shaping the agenda together. De quoi s'agit-il? You identify the respective interests. You try to, gather mutual options again, and then you bring solutions to the table. And if you do that, then you can forge a settlement agreement together, and it's easy, and it avoids ending up in this situation. And I'll leave you with that. Thank you for your attention.
Thank you. Yes, we are left with the baguette, and unfortunately, yes, we don't have any time for question and answers. I thank all of the panelists. It was a wonderful panel with exclusive content. I thank the audience as well. Thank you for waiting for us to finish, and I leave the floor to Fanny. Thank you very much, Yasmin and the panelists. So I guess all the speakers have agreed to share their slides. So we will circulate those slides in a PDF format. If you have any objection, just let us know. So now we will have some closing remarks just before the cocktails. So we will welcome again our presidents of CICA and EIC.
Okay, thank you, Fanny. So a few words as a conclusion. I will not summarize everything. It was so rich and very interesting, and maybe too short time. Maybe we have to spend a full day to have enough time to enjoy all the added value brought by everybody. It's not a new approach. It's collaboration, as we know already. But we think it's the right timing. It is the right timing to develop this collaboration everywhere. Why? because we call our world VUCA world, BANI world, it's a new world, but at the end, it's a complex world. And to better face this complex work, we need reactivity, flexibility. It's why we think collaboration is a must to face this new world. Second reason why we think it is the right timing, it's also because we are facing nowadays in the construction industry lack of resources, less and less competent resources. It means that our clients have less and less construction contractors to deliver their mega project. So we think that it's another reason to develop collaboration, because when you are doing collaboration, you are saving resources. So it's why also we think it's the right timing to develop this new collaborative approach. Third reason, and we didn't speak about this morning, but don't forget, we have less budget. Our clients have less budget. Our world is not so rich, and we don't know tomorrow. So our obligation is to do more with less everywhere, more with less. So it means that we need to work together. It's the only way to be able, as human, to do more with less. So it's why we think it's the right timing to foster this collaborative approach. Two things. One success key factor. We touched it many times during the presentation. People. And I think it's nice to hear that we still rely on people in this era of artificial intelligence. We need people with the right behavior. We spoke about communication. We spoke about transparency. It means it's another world where we're more able in terms of individual to work all together. And it's crucial. So it's an essential key factor. And starting by our client, we said the client, he has to drive the show somewhere. And so he needs definitely to have the right people to drive the show. Last point to conclude, a condition. If we want to be successful, there is a big condition. The big condition is to change our behavior, change our habits. If I take an example, traditional way of our overall construction chain is to have on one side the client, the employer, and the engineer, it's one side, fighting with the construction. It is where we're coming from. And our people, they are used to fight each against other, So we need to move out of this traditional scheme. We need to change our behavior, our habits, to be able to invent another scheme. And as CIC, we think that, and we start to implement this new scheme, is to move out of our construction silo and to board with us engineering, because we think that together, engineering and construction, we're able to deliver the solutions required by our client. So we need this. And the question I will let to you as individual. Think about, are you ready to face this new challenge while working together for a common challenge and forgetting your own interest and the own interest of your branch? Thank you.
Yeah, thank you, Benoit, for this words. I mean, I will not repeat, of course, what you said. I mean, just maybe adding something that we are living, unfortunately, in a more and more complicated world. I mean, yeah, it's today some topics that we never heard about. I mean, climate change, net zero emission, measuring the carbon. So it's quite, let's say, difficult for contractors also to swallow all this new regulation. I hope this discussion today has improved, let's say, the way contractors can and will perform in the future. I mean, we need, like Benoit said, more cooperation. I mean, it was said already today, so we need to cooperate between the various parties. I would like to thank, of course, all the participants today. I mean, the speakers, FIDIC, NEC, WAP, Mr. David Mossy. And then also, let's say, I forgot to mentioned before that we had also the European Commission here in the room. We have also EBRD in the room. So let's hope that we can continue the discussion with both of you and some other MDBs. I mean, for CICA, we will continue, let's say, the topic, of course. So you're welcome to join any working group. I think EIC also will continue on this topic, and together EIC CICA. So we intend to publish, let's say, a concept note on collaborative contracting. I mean, with the help also of Professor David Mossy. So we are welcoming your contribution and your participation in this. I think I will also mention that we have with CICA a few webinars ongoing. So some with NEC, I mean, we had in the past with FIDIC, we have also with DRBF. So you are welcome to follow this webinar. They are free and you can register easily. They are published on LinkedIn quite regularly. A last note on my side, I mean, so it's the end for me for the 2 years presidency term of CICA, and I will introduce you the new president. I mean, yeah, Juan Armando Vicuna from Chile. So at least, yeah. So now you can put a face on the next president of CICA. So we welcome you for the lunch, and I think, I mean, we'll be a bit late for the bus, but I mean, we will delay it if needed.
As it's the time for invitation, I will invite you also for our next EIC event. It will be in Bordeaux, in France, a very nice place, you know, with good wine and everything. And the topic will be also very, very interesting. It will be about decarbonization of infrastructure construction, and again,